has been two other appearances, Mr. Aranno Shah and Mr. Ajay Choudhury.
Ms. Munmun Theory is not there.
No, not at all.
Must have been given in some slip.
Something might have slipped off, my lord.
So give the correct names.
Yes, shall I hand over the fresh copy of the judgment also?
Need not. In the judgment dated January 17, 2025, comma, the appearance of advocates on behalf of the respondent in APCOM 229 of 2024 and the petitioner in APCOM 255 of 2024 was erroneously recorded. Full stop. The proper names of the advocates appearing in the matter should be, comma, in the following order: colon দিয়ে 1. Mr. Shubhobrata Dotto, DATTA; 2. Mr. Aranno Saha; and 3. Mr. Ajeo, AJEYO Choudhury. এখানে বানানগুলো লেখা আছে দেখুন। Full stop. Let this order be deemed to be a part of the order dated January 17, 2025. Let this order be deemed to be a part of the order dated January 17, 2025. ঠিক আছে, নামগুলো বানানগুলো এখান থেকে যদি দেয়। নেক্সট 10:30 টা করে লিস্ট নেই তোমার কাছে? Yes.
Lordship, may kindly take your Lordship's last order.
Yes.
Dated 17 January 2025.
My lord, we have been able to, my lord, get the matter listed as item numbers 12 and 13.
Yes, Mr. Mojumdar, what do you say?
My lord, the appeal is listed today. That's a fact. My lord,
let us wait till next Friday. Learned Advocate General submits that the appeal against the parent order has been listed before the appropriate division bench, fairly up in the list. Full stop. Accordingly, comma, to await the decision of the appellate court, let the matter stand adjourned till February 14, 2025. For the time being, comma, further personal appearance of the alleged contemnant is dispensed with. If necessary, will. না 10:30 থাকবে, dispensed with করে দিয়েছি বলে 10:30 থাকবে।
For the judgment data, my lord.
Right. Recall application is your application?
No, pilot.
You are for the judgment data.
Judgment data.
Lordship,
You have asked for recall.
Recalling application.
What is the what is the ground for recall? What was the order?
The last occasion.
Whose application for recall?
Yeah. Respondents.
Respondents.
That is what I asked you. Your application for recall, you are saying no.
Sorry.
Why recall? What is the order?
Well, a warrant of arrest has been issued on last occasion.
So why should you recall?
My lord, his financial capacity is very unwell. He is unable to pay on 37,000 every last 2 years. He have paid on 19 and 20.
Warrant of arrest because he did not appear.
Yes, my lord. And he did not participate in the arbitration proceedings also. But kindly.
No, if he could can appear through counsel now, he can very well appear before the court. Just because he does not have the capacity does not alleviate his responsibility to come before the court. Warrant remains. No question of warrant being recalled. Why should you recall?
They have not even filed the affidavit of assets.
So you are not complying with court's order. I'll reject the recall application. The warrant of arrest remains. The petitioner has been filed by the judgment by the award debtors in connection with an arbitral award. Full stop. Learned counsel for the petitioner submits that the that the award debtors are not in a position to meet the award due to their financial insolvency, financial incapacity. Full stop. Next para. However, by the order of which recall has been sought, comma, warrant of arrest had been issued for non-compliance of the court's order by not filing affidavit of assets and or appearing before the executing court. Full stop. Next para. I do not find any reason as to why such non-compliance is mitigated due to the financial incapacity of the judgment award debtors. Full stop. In the event the award debtors have difficulty in paying up the awarded amount, comma, it was for the award debtors to appear before the executing court as per the direction of the executing court and also to file their affidavit of assets to that effect. full stop, having not done so, comma, I do not find any scope of recall of the order of issuance of warrant of arrest, full stop. Accordingly, GA-Com 1 of 2025 is dismissed on contest. Full stop, the warrant is sustained. Next. Come before the court, file your affidavit as it say I have nothing and appear before the court. Next.
Affidavit of asset today filed.
Lordship, with the
No,
copy
there is
of
no scope of my taking the affidavit. Please return Korda. This court in a recall application cannot take it. You file it before the appropriate court.
Review application.
Yes.
Uh,
Yes.
May I, my lord?
On the last occasion, Mr. Gupta had completed, Mr. Dev.
Right.
My lord, let me, my lord, deal with his points, my lord. First point, my lord, which I urged, that review application is not meant.
As I said, you have not filed your written notes, right?
No, my lord, today I will be
Right.
filing.
Yes.
Today I will be filing.
Yes. Yes. Make your oral arguments, I'll take.
But first point which I urge, my lord, the review application is not maintainable. In view of what has been, my lord, narrated or provided in Order 47, Rule 1. Discovery of new fact, due diligence, and error on the face of it to be read with, my lord,
Any other.
other reasons. This other reasons has to be, my lord, to an extent, principles analogous thereto, the principle will apply here.
Yes.
Analogy has to be drawn. Why I say this? Because they said it's a misconception of law. Just to counter that. My lord, I cited, my lord, two judgments on the first day. One is 2021, volume 13, Supreme Court cases, page 1, paragraphs 9 to 15.
Yes.
That is for the proposition that a judgment, my lord, can only be reviewed if there is a mistake or error is apparent on the face of the record. The scope is very limited and it cannot be allowed to be an appeal in disguise.
Right.
An erroneous decision or an order cannot be corrected, my lord, in the guise of exercise of the power of review. Otherwise, my lord, the provisions of Order 41 will be obliterated.
Yes.
It can't be done. The another decision which I cited, my lord, 2006, volume 1, Supreme Court cases, page 509, paragraph 12.
Right.
That is for the proposition that a party or a person cannot be permitted to re-argue on the points on review petition which has been rejected earlier.
All right.
And this is exactly what they are trying to do. Now, my lord, they have cited two judgments on review. I will come to that later. They said one judgment, which is 1981 Supreme Court. My lord.
1 second, Northern India Cataracts was cited by you. 80. Sorry, please continue.
But that they said, my lord, it's a 3 judges bench, and the judgment which I cited, both are 2 judges bench. So, my lord, today I found one 3 judges bench. That is, my lord, 2022, volume 17, Supreme Court cases 254. So kindly have a look at this. It says the same thing, my lord. Just
Have you got a photocopy right now?
I will provide, my lord.
Can I take a note? Please repeat the citation.
Let me, my lord, hand over the book. I have an extra book, if lordship considers, my lord.
I'll have to take a note of this.
Yes, yes. my lord.
You will be furnishing the photocopy during the course
Yes,
of the
yes,
day?
of course.
Well,
Certainly, my lord.
then hand it.
2020, volume 17, Supreme Court cases 254. 2000, কি দিলি রে? 2020 to 2028. Well, that is 2022, volume 17, Supreme Court cases, page 255, paragraphs 26 and 33. I only have one book, my lord.
Very well, you can just
Very well.
place it.
I'm sorry, my lord.
No difficulty.
When review will not be maintainable, and here also, like the other 2 judgments which I cited, review petition was dismissed. Here also it was dismissed. It considered all the other judgments, including the one which I cited, 2021. A repetition of old and overruled argument is not enough to reopen concluded adjudications. Minor mistakes of inconsequential import. Review proceedings cannot be equated with the original hearing of the case. Review is not maintainable unless the material error manifest on the order, on the face of the order, undermines its soundness or results in miscarriage of justice. The review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. The mere possibility of two views on the subject cannot be a ground for review. Then, my lord, other things also, review is not maintainable when the same relief sought for at the time of arguing the main matter had been negative. So these are the propositions, my lord. And another paragraph, my lord, that is 26. I will be handing over the photocopy. 33. It, my lord, discusses in detail what is, my lord, error on the face of it and an erroneous decision. May I, my lord, please. As can be seen from the above exposition of law, it has been consistently held by this court and several judicial pronouncements that the court's jurisdiction of review is not the same as that of an appeal. A judgment can be open to review if there is a mistake or an error apparent on the face of the record. But an error that has to be detected by a process of reasoning cannot be described as an error apparent on the face of the record. For the court to exercise its power of review under Order 47, Rule 1 CPC. In the guise of exercising the power of review, the court can correct a mistake, but not substitute the view taken earlier merely because there is a possibility of taking two views in the matter. A judgment may also be open to review when a new or important matter of evidence has emerged after passing of the judgment, subject to the condition that such evidence was not within the knowledge of the party seeking review or could not be produced by it when the order was made, despite undertaking an exercise of due diligence. There is a clear distinction between an erroneous decision as against an error on the face of the record. An erroneous decision can be corrected by the superior court. However, an error apparent on the face of the record can only be corrected by exercising review jurisdiction. So this is what the principle is, my lord. And there is no departure to that. Now, what my learned friend has cited, I will distinguish those two, my lord, judgments. On this, my lord, one is 1982, Volume 2, Supreme Court Cases, Paragraph 8. And the other one, 2005, Volume 4, Supreme Court Cases, 741, Paragraph 19. My lord, sorry, 1980, Volume 2, Supreme Court Cases.
1980 volume 2,
1980, Volume 2.
page 167. And the other one is 2005?
5, Volume 4, Supreme
Yes,
Court
yes.
Cases, 741. Probably, my
Same
lord,
hunch.
probably, my lord, I'm sorry.
Yes.
Probably, my lord, in both the cases, review got dismissed. However, he referred to a particular proposition of what is misconception of law. Now, my lord, as I submitted, my lord, at the very outset, the misconception of law has to be read with the other three things. Erroneous decision and misconception of law is completely two different aspects of the matter. Suppose the law has been laid down on a particular thing, and there is an omission or departure to that, which is apparent on the face of it, can be construed a misconception of law. Now, if a detailed scrutiny is required, then certainly that is, my lord, beyond the scope of the review. My lord, what I am trying to say, my lord, supposing, my lord, for the purpose of attracting or for the purpose of, my lord, pursuing the court that a suit is barred or a claim is barred, I refer to a particular article and my adversary relies on a different article. And the court, my lord, while coming to its finding, discussing everything, says this particular provision of law will apply. That is not a misconception of law. At best, you can say that's an erroneous decision. For that, you have to go to the higher forum. Misconception of law, my lord, my understanding subject to what falls from the, my lord, when I totally ignore the law on the subject, and that has to be apparent or evident on the face of it. If you invite the court to scrutinize in detail beyond the scope of review. And that omission has to be glaring omission. 1982 volume 2, 1980 volume 2 Supreme Court cases, paragraph 8, it's a glaring omission,
Yes.
patent mistake. So where is that, my lord? So these two decisions in my respectful submission do not apply, my lord, do not support my learned friend's case. Now, my lord, coming back to the points, my lord. Here, my lord, I'm sorry, my lord.
Yes, same.
My lord,
And in regarding 2005 volume 4 also.
2005 is, my lord, the misconception of law, paragraph 90. And the 1980 is about glaring omission, patent mistake, grave error. That is on the basis of which this judgment has been cited, which is crept in, according to my learned friend, and what the court observed for the purpose of holding that review is maintained. I said these factors are not present in this case. How far, my lord, the concept of misconception of law has to be stretched. Otherwise, my lord, all will come under misconception of law.
Yes. Any legal error will come.
Yes, any legal error. And the order 41 will become redundant.
Right.
Now, my lord, the second thing, my lord, Lordship knows, my lord, the facts of the case, what had happened. Here, my lord, an award was passed. In the award, all the judgment debtors were made parties. They belong to a particular group, Gupta group. My learned friend says it is inseverable. No, that's not correct. Because everyone has a different, my lord, area in the property, Chatterjee International Center. Bills are raised on everybody. On the basis of their possessory right, the maintenance bills are issued, including the car parking area, and they pay that. Now, when the reference was made, which finally culminated in the award, there were several references. Finally, one award was passed, and that's a consent award. So, severability is always there. Today, I occupy flat number 3 in Chatterjee International Center. You occupy flat number 2. You may belong to a particular group. Bills are raised on the basis of your occupation and possession. And if you enjoy a car parking space, yes, another bill is raised. Otherwise, there would have been only one bill. No, it's not that. Though it's a new fact, but I have to counter. But these things should have been pointed out. And second thing, my lord, when the execution application was served, when the appeared, they said I had no knowledge about it. But if Lordship sees the orders, in all orders they appeared. A particular scrap material was sold. They appeared and taken money. They never pointed out that I am taking money for everybody but for this particular gentleman who passed away. No, it was never stated. So you accept on behalf of everybody, you take money on behalf of everybody. Now it doesn't lie in your mouth to say after taking benefit of it.
They appeared at which stage? In the arbitral proceeding or
Before the court, my lord.
in the executive court?
Yes, Justice Boshak's order, my lordship, referred to in the original judgment.
All right.
And most importantly, I am tempted, my lord, to just, my lord, refer to these documents.
Yes.
I have not got an opportunity to file an affidavit. Just kindly have a look at this document. When they accepted money, what they have said.
Give a copy to them also.
Yes, I am giving, my lord. Kindly see. As constituted attorney, when the money was distributed, Lordship knows, my lord, Lordship has recorded.
But I probably I cannot look into this.
Yes, Lordship did not. But the factual aspect, what has been sought to be heard is incorrect. Sought to be heard is incorrect.
So new fact is sought to be brought in, which is incorrect also.
Absolutely. Now I am on merit.
You may put it in your written notes of argument,
I have done it. I have done it. I am very reluctant to point out, but this fact should have been pointed out when you raise this issue of bona fide. You said my action was mala fide. Deliberately, I did not do. And section 21 will not apply. Now, my lord, kindly comes to their review petition. Just 2 or 3 orders I would point out to show their mala fide, my lord. First, my lord, page 61. I'm not troubling your lordship to look into the order of Justice Boshak because that has been recorded by your lordship in detail while considering my argument of approbate and reprobate. That admitted position you have taken money and taken money on behalf of everybody. And that basically can be constitute your implied knowledge to the execution proceedings. Kindly sees, my lord, page 61. Why I place it, I will tell you, lordship, my lord, immediately. Lordship has got it, my lord?
Yes.
Learned advocate appearing in support of the applicant submits that some of the respondents died. Kindly take note of the date. 7 December 2020.
Right.
Learned advocate appearing for the surviving respondent submits that the particular of the date and the heirs of the deceased respondent were provided by the learned advocate appearing for the petitioner. Learned advocate appearing for the petitioner seeks for adjournment. Some of the judgment debtors died. This was pointed out. Their names were brought on record by you of a substitution. Date of the order is 7 December 2020. Now, my lord, when this gentleman, my lord, passed away, when did he pass away? Aditya Vikram, 2014. 2014.
Yes.
This is, my lord, really with regard to their motive I am placing. I will be arguing, I will be meeting with all.
Their argument is, if I understood them correctly, is not only that you did not implead the heirs of the deceased, but you did not implead the original awardor also. That particular person.
I'm coming to that.
So it would be bad for that also, even forgetting his demise.
That's not. I will come to that. I'm just on factual acts, then I will go back to the law, my lord. Now, my lord, when we came to know about the death of this particular gentleman.
So before the EC was filed, he had died.
He died in 2014. And I tell you, lordship.
That was after the passing of the award.
After the passing of the award.
But before filing of the EC.
Before filing of the execution.
All right.
Kindly comes to, my lord, page 63. First time when they took this point. So in 2020, when learned advocate appeared on behalf of all the judgment debtors, he had knowledge. Because he died in 2014, and that revealed when my learned friend argued. He said in 2014, Aditya Vikram died. This was never pointed out. Page 63 kindly sees the order. Learned counsel for the award data points out, on this day, 19th of August, this was pointed out for the first time after taking benefit of it. And Millard, court records the fact, and they agreed they will provide the names of all the legal heirs. Kindly turns over to the next page, Millard. What did they write, Millard? The date of death. The advocate's letter.
24.
20. Millard, kindly have a look at.
There was no corrigendum. No corrigendum to this.
Nothing. Now, Millard, kindly have a look at order 22. The duty of the plea. Order 22. There has to be a limit to this, Millard. Order 22, rule 10A.
But you also have to keep in mind that order 22 is not applicable. That is also their argument.
Yes, I will come to that. But their argument is that execution is not continuation of a suit.
Yes.
They have relied on Justice Bhaskar Bhattacharya's judgment. I will praise that. It supports me. It supports me.
All right. Yes.
One paragraph at least.
All right.
They say Limitation Act does not apply, but on the first day they say Limitation Act applies. I would take all their points. It applies, it doesn't apply. Both ways.
Yes.
So, Order 22, Rule 10, says duty of pleader to communicate to a court death of a party. When a pleader appearing for a party to the suit comes to the date of party, he shall inform the court about it, and the court shall thereupon give notice to the date of the other party and the for the purpose contract between the pleader and the deceased party. Now, my lord, may I cite Supreme Court on this? But kindly have a look at 2008, Volume 8, Supreme Court Cases, page 321. I'm giving my lord a copy. 2008. Kindly have a look at this. my lord.
And in the meantime, Mr. Dev, please ask your clerk to have a photocopy of that other.
Yes, yes. देखिए, 2022 है. 2022 है. There you go.
You have a photocopy of that. Thanks.
You would also intend to, you were
नहीं,
ready to
नहीं.
distinguish this one.
Yes, yes. आज के तो बोलते थे.
है ना? Ready to distinguish नहीं है इसकी.
अच्छा.
देखिए,
Same copy. He has got it. He probably anticipated there will be
Same
citing.
thing, ওনারটা ফেরত দিয়ে দাও.
He anticipated maybe I will be citing this.
No, not this. I was wanting the other copy.
2022, my lord. This
The one you cited gave the book.
yes,
That one.
2000.
Oh, this is that.
Yes, yes.
Acha.
Paragraph 26 and 33. Lordship can take note.
He has already got the photocopy.
Yes. He anticipated the three judges issue. Now, my lord, kindly comes to paragraph 13 to 17. 2008, volume 8, Supreme Court Cases, page 321.
Yes.
Paragraph 13, my lord, to 17. Paragraph 13, my lord, it talks about the sufficient cause, about condonation of delay relating to substitution. Though it is really, in my respectful submission, this case, my lord, is not about really substitution. The fact is, one particular judgment debtor has been left out in the execution application.
Yes.
Others represent his interest, proved beyond doubt by their conduct. When this was pointed out, we, my lord, accepted it. We said it's a bona fide mistake, and we wanted to add.
This is not actually a substitution scenario. This is a scenario where, like in an appeal, if somebody dies in the meantime between the decree and the appeal, you take out an application for leave to prefer the appeal against them also. So you ought to have filed an application for leave to levy the execution against these heirs of these deceased.
Absolutely.
That is the
Absolutely.
situation.
Now, my lord, here, my lord, the court passed an order. Court permitted me when this was pointed out. They provided, my lord, the names of the heirs. After taking benefit of the order, then, of course, on the next day when the execution was about to be argued, they said, no, 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 entire claim is gone. Not against me, the legal heirs, but
All.
against all. All. Why?
That was an alternative argument. To
Inseverable.
be fair to them.
Absolutely. So I said severable on the face of it. I will show
Yes,
you
that
the-
you have dealt with.
Yes. Now, my lord, paragraph 13, diligence and action, it says, now, my lord, kindly comes to the important paragraph which I want to place, paragraph 17, about the bona fide really I'm on this. What is the duty of the pleader and the counsel? How can you suppress this? Paragraph 17. I'm not placing, my lord, the sufficient cause and all that, lordship knows, my lord. Paragraph 17. The second circumstances is whether the counsel for the deceased respondent or the legal representative of the deceased respondent notified the court about the death, and whether the court gave notice of such death to the applicant. Rule 10A of Order 22 casts a duty on the counsel for the respondent to inform the court about the death of such respondent whenever he comes to know about it. When the death is reported and recorded in the order sheet proceedings and the appellant is notified, the appellant has knowledge of the death. And there is a duty on the part of the appellant to take steps to bring the legal representative of the deceased on record in place of the death. The need for diligence commences from the date of such knowledge if the appellant pleads ignorance. Even after the court notifies him about the date of the respondent, that may be an indication of negligence or want of diligence. So in this case, their argument that I was not diligent, that goes, my lord, because I was not informed or aware of the date of that.
But
person.
Mr. Dev, even if you are not aware of the death, you could have implemented Aditya Vikram.
Yes, I did. I didn't. I couldn't. But I candidly, my lord, submitted. It's a bona fide mistake. I just missed out. Now, what would be the effect of it? Whether the law, when a particular gentleman's interest is sufficiently, my lord, protected by appearance of the other parties.
Can you say that in the same breath? You say it's severable, and you say his interest is protected by the others. Can these go together?
My lord, this is in order to counter their argument. It's inseverable.
Yes, but you're blowing hot and cold in the same breath.
I
aren't
tell your
you?
lordship. I would go by their conduct here. You have accepted money. When the money has been paid, you have accepted on behalf of everybody, including that particular death person.
How can we be sure of that? I mean, where do we get that?
from the letter from the conduct, the letter which I handed over.
They said on the behalf of the surviving heirs.
My lord,
That
may I, my
language
lord?
has been used always. They have never represented Aditya Vikram.
My lord, may I, my lord, place that letter once, my lord? Just, my lord, that letter.
Yes, yes.
I, Harshvardhan Gupta, am the constituted attorney of all the judgment debtors of the...
Which letter, which page?
My lord, it's the only letter, my lord, it's email. It's a mail dated 10th June 2020.
It's annexed to the review application.
No, it's not. It's not. It's not.
Then I returned it to you, in fact.
Yes. But the fact remains...
But you have not filed any opposition to the...
I did not. I didn't want to, my lord. I didn't want to.
Then
But very well, Lordship would
cannot
ignore
take it
this.
on record.
Lordship would ignore this. Lordship would, my lord, go by the order. Lordship would go by the Justice Boshak's order.
Justice Boshak's order only reflects that they were appearing for the surviving heirs.
My lord, surviving...
Judgment debtors.
So what surviving was possibly, my lord, I'm just... It is
Surviving is there, yes.
not... My lord, may I, my lord?
Please come back to that.
My lord, I don't think it has been annexed.
Page 61.
Page 61 is not that order. Page 61 is about the recording of death of few gentlemen.
Which other order? If it's an order of court, you can hand over a
It's an
copy.
order of
Even
court,
if it's not there in
such
the...
order is an order of court.
Even if it's not there,
I'm trying
not
to find
annexed,
out.
you
I'm
can...
trying to find out. My lord.
Yes, you can.
Lordship's judgment, my lord, records that fact, my lord. I would come to that, my lord. I will show it from your lordship's observation made in that. And also trying to find out that order, my lord. Because
Very
possibly this order has not been annexed. Page 61 is not the... Page 61 is recording the death of few...
Not page 61, some other order of Justice Boshak.
When you did not disclose about the death of that particular gentleman, though he passed away before that. Yes, my lord, give me a minute's time.
Yes, yes, take it.
Yes, my lord. Paragraph 20, running page 10 of my lord's judgment. That's part of the stay petition. And also part of the memorandum of
10, yes.
Paragraph 27, page 10.
Yes.
Lordship, my lord, kindly sees.
Yes.
The other money component in the award is the agreed term between the parties to share the sale proceeds of air conditioning plant at 50-50 ratio between themselves. By orders of court dated 19 February 2021 and July 15, 2024, on consent of the parties, the sale had taken place and proceeds thereof had already been distributed between the parties in such shape. Hence, such other aspect of money award has also been satisfied in consent and without objection. And the surviving ward, my learned friend is checking it, probably is not there because I appeared, subject to correction. This order, 19 February 2021. It's not there, surviving. Never said that. So accepted money on behalf of everybody. Now, my lord, the question is, whether, my lord, on a review petition, court will go into this. Again, this point comes. My answer will be no. Now, my lord, let me deal with this other points. I have said it's an implied consent to the execution because all throughout you appeared. In any event, my lord, the award sought to be executed when it became deemed decree after a period of 2 years. And lordship knows order 21, rule 22. Notice. The court directs, my lord, a party to issue a notice. I have read it. Like in a contempt petition, sometimes what happens, my lord, we, by of an abandoned caution, my lord, we serve. But the court says
Yes.
it's between the alleged contemner,
Right.
you serve. So order 21, rule 22 says when you move it after 2 years, what shall is there in order 21, rule 22? I've checked it.
Yes, yes.
So that takes care of the situation. Now, my lord, the main point is order 1, rule 10 and non-applicability of that provision in execution.
Order 22 Rule 10 or order?
No, order 22, my lord, I have submitted as a duty of the pleader
All right.
relating to their negligence,
All right.
deliberate ploy of avoiding a situation.
So order 1 Rule 10 now.
Order 22, though they did not argue, I thought, my lord, what about the duty of a pleader?
Yes,
when you
exactly.
say it's negligence, when you say I deliberately did not do it, these factors will come and this will be shown against you because you have done it. And court order records such fact. When the gentleman passed away in 2014, in 2020, you put it on record about the heirs of other gentlemen, but not about this particular gentleman. So my knowledge comes when I came to know. Now, my lord, order 1 Rule 10 and order 1 Rule 9. Though it had been placed, it's really re-arguing, but since he has argued, my lord, let me, my lord, deal with this again.
The order dated 19th of February passed by Justice Bosher. I had one copy, my lord, I'm handing.
Thank you.
লেখা আছে surviving বলে
Yeah,
কোথাও?
advocate on record of the judgment date.
Correct.
লেখা আছে।
Correct.
Then you can hand over a copy to them.
The first order.
Soft copies.
If you,
Well,
you should have a soft
not
copy,
this
yes. You
order.
can take out 19th February 21 order.
Yes.
Thank you. Thank you very much.
And possibly I appeared, so that was not. Anyway.
Yes, you did.
Surviving word is not there.
No,
Not there.
no, he's being fair only.
No, that's true.
Very. Even they did not know at that point.
So they say
Well, I mean, council did not know.
council did not know.
Obviously.
Represent the same group, council did not know.
If the council knew, they would definitely have pointed out. Yes.
না না তোমার কথা কিছু নেই I would never say against you. Client takes money. Clients know the death about all his friends except the gentleman who has been left out by mistake.
Yes, yes.
You appear all throughout in execution. You take money, you take all benefit. Say execution has not been served. So entire execution goes when the cause of action is running and continuing. Even today I have a right. It's continuing because you are not paying the maintenance charges. What is the real cause? I will not pay the maintenance charges. Though I will enjoy possession. And in fact, my lord, they also filed a my lord execution case. Seeking enforcement of that part. It's not the subject matter here. Now, my lord, order 1 Rule 9, misjoinder and non-joinder of parties, my lord. It clearly says, my lord, no suit shall be defeated. Proviso is there, provided that nothing in this rule shall apply to non-joinder of a necessary party. Now, my lord, order 1 Rule 10, this principal argument. Court at any stage, my lord, can add or delete if improperly joined. I placed it. Improperly joined, deleted, necessary, either proper or necessary party, decree or your presence for effective adjudication, court can at any point of time. Now the word proceeding is there at any stage of the proceeding. He says suit and execution are two different proceedings. That's his first argument, which I have noted. First day. Then he, on the next day, said, countered that limitation, but I will meet with that. No, my lord, that's with greatest of respect is not the correct submission. Execution is subtly, my lord, continuation of the suit. Accord and satisfaction is there, my lord. Execution is not an independent proceedings. It arises out of a decree. Decree needs to be executed and full satisfaction is required. And how that is done, that mode has been prescribed in the Order 21, the procedural part. That is how a decree has to be executed.
But it continues, Mr. Dev. If you rely on proceedings, the court may at any stage of the proceedings, either upon such and such,
Yes.
whether as plaintiff or defendant,
Yes.
or whose presence before the court may be
Yes.
necessary in order to enable the court to effectually and completely adjudicate
Yes.
on the suit. So suit and plaintiff and defendant are an essential part of that same sentence.
Now, my lord, I say it's like appeal. The execution is, my lord, a continuation of the suit. So this principle of Order 1 Rule 10 will apply.
Should be applicable in any event.
Because there is no specific provision. Otherwise, my lord, a suit is decreed. if somebody passes away, the execution will fail, or his legal heirs are to be implemented as parties for the purpose of satisfaction of the decree who has got the decree in his favor. Entire case will go.
They simply say that Aditya Vikram non-joinder renders the execution case barred by limitation insofar as Aditya Vikram or his.
Because it goes back to the original proceeding.
Yes, not that, but the execution case itself is barred. There may be a scenario where there is a suit, a decree, valid decree, but your execution case is barred. Let us forget there are many judgment debtors, even if there is one judgment debtor. You file the execution case beyond limitation period for filing.
I filed in 2015.
No, not that. But we are taking a hypothetical situation. If there was one award debtor, you filed it beyond time, the limitation period, then it would be time barred. Therefore, there is a suit, but there is no continuation because it's time barred. Now, in this case, regarding Aditya Vikram, if you say the interests were severable, then insofar as Aditya Vikram is concerned, at least, when you levy the execution case is the time when you bring in that party or his successors. At that point of time, the execution was time barred against him. So why should it be executed against Aditya Vikram or his successors?
21.
That is why it's
21.
cited judgments and all. I mean, Section
Section
21 is not applicable.
Whether it's a bona fide mistake or not.
They say Section 21 is not applicable also.
Absolutely. There's a limitation will not apply at all.
Yes.
Though they refer to a provision. And I tell you, Lordship, the period of limitation is 12 years.
Yes.
That's what they say.
So you say if Limitation Act applies, 21 should also come in.
Certainly, my lord, certainly. And Order 1, Rule 10 says the limitation applies. And
Yes.
one article, my lord, on the last day,
Limitation Act.
136. That's the relevant article which they relied upon, according to them.
Yes.
Kindly sees, my lord, a catch there.
They
say it's a money claim. Proviso, kindly sees.
Hmm.
What's the prayer in principal prayer in the execution injunction? And cause of action is continuing and recurring. So will it be barred? Kindly see. 136 they referred to.
Yes.
For the execution of any decree other than a decree granting a mandatory injunction or order of the court, 12 years. That's what they wrote.
Well, that was also probably either considered or I put the question to them.
Lordship considered. Lordship
Either in the original order I
yes,
considered.
Lordship recorded. When I showed the proviso, kindly see the proviso.
Yes.
Provided that an application for enforcement or execution of a decree granting perpetual injunction shall not be subject to any period.
That is there.
It takes care of that. And if you see the award,
yes.
What is the award? It's by consent.
That was also one of the grounds of the parent order, probably that money has been satisfied. The money component has been satisfied and now injunction remains.
It's a recurring because you are not paying it. That's the principal claim.
Right.
And in the award, it's a consent award. Consent award of what? Lord, I tell you, Lordship, I'm not taking your Lordship to certain facts, though I say court should not at all, because court doesn't sit in appeal while deciding the review. What's the consent award? I tell you, Lordship. Section 9 application was filed in a civil court. Then, my lord, party aggrieved came before this honorable court, before the division bench. Matter got settled to an extent. Both parties agreed. How the agreement took place, my lord, by writing letters. One advocate wrote to another, and that was recorded in the order by the division bench, presided over by Justice Oshim Banerjee as his lordship then was. Matter settled. Each party has an obligation. That has been recorded in the letter. Both the letters. Lordship can take it from me. Now, those letters, my lord, they did not act upon. That's why, my lord, we filed arbitration proceedings. And not about the money thing. Lordship would find from my relief that I sought for in the execution, it's really about using something which you are not supposed to use. You are using a car parking space which you don't own. You are not paying the maintenance charges. Where is the money claim there? It's a consent award you have not acted upon. That given me a rise to that, my lord, given me a right to proceed against you because cause of action accrued the moment you breached your obligation. That was there in the, my lord, compromise. That's the award. Now, my lord, I say it applies and I showed you article, my lord, 136, which they relied upon. Then, my lord, kindly, my lord, consider one judgment. 1992 volume 4 Supreme Court cases. It's approbate and reprobate. Again, I'm troubling your lordship on the merit, but I have no other choice because they have addressed. Though I say court certainly cannot. 1992, volume 4 SCC, Supreme Court cases 683. It's a doctrine of election, settled proposition of law, my lord.
এটা কি একটু নিয়ে যাওয়া যাবে?
Paragraph This is about accepting the order, accepting the money, then acting contrary to the paragraph 10, my lord. May I, my lord, please?
Yes,
I'm sorry, my lord.
yes.
Law does not permit a person to both approbate and reprobate. The principle is based on the doctrine of election, which postulates that no party can accept and reject the same instrument, and that a person cannot say at one time that a transaction is valid and thereby obtain some advantage to which he could only be entitled to on the footing that it is valid, and then turn around and say it's void for the purpose of securing. You have taken advantage of a particular proceeding. You have taken money. You have accepted everything. That implies your consent. And how you have accepted? Accepted on behalf of everybody. You never said that I have taken money for the surviving judgment debtors, which rightly Lordship Millard pointed out. That was never there. I mean, forget about the conduct. Somebody dies in 14, you say in 2024. Well, less said is better about this. Now, Millard, I submitted before your Lordship, Millard, suit, Millard, execution is a continuation of the suit. That's why, Millard, this principle will apply. Order 1, Rule 10. Because there is no other provision. Otherwise, everything will become redundant. Kindly have a look at a judgment of Bombay High Court Division Bench, Millard. AIR 1981. Paragraph 6, Millard. Millard, take my copy, Millard.
No, find out your copy. Take your time, find out the second copy.
1981, Bombay, paragraph 220. Paragraph 6, Millard.
Page 230.
220. May I, Millard, read out, Millard? Yes, Millard, permit me to place it, Millard, then I will hand over my copy, Millard. Paragraph 6, Millard. It's a division bench, Millard. The above judgment has not taken into account the previous ruling of this High Court, including the division bench ruling. All these judgments have laid down that execution proceedings are a continuation of the suit, which was originally filed. If the suit in which the decretal rights have been created was filed prior to coming into operation of the Tenancy Act, then the execution proceedings which are taken out in that suit subsequent to coming into operation of the Tenancy Act are not affected in any manner by the provisions of Tenancy Act. That's a different thing altogether. The distinction sought to be made by the learned single judge between a suit in which a plaintiff has initially claimed the right which is conferred on him by the decree and a suit in which a right is not initially claimed by the plaintiff is also not warranted. In our view, it is not open for a court to say that only in a suit where the rights are intimated, claimed by the plaintiff is confirmed by the decree, will be the court treat the execution application of that decree as a continuation of the original suit proceedings. In all cases, irrespective of the cause of action pleaded in the an execution proceeding is a continuation of the original suit which was filed.
So this is for the proposition that Order 22, Order 1, these apply.
Certainly, my lord. Certainly.
Good.
No, my lord. There is one judgment which I found out, my lord, that is relating to their argument that Order 1, Rule 10 does not apply to execution. That's the next day which he argued. The Limitation Act certainly applies, my lord. There's no doubt. Order 21, Rule 10, 5, I think, Sub Rule 5 clearly provides that. And if it applies, which he agreed on the first day and disagreed on the next day, self-defeating argument. Referring to Article 36, it helps me because my claim is simplicity or injunction running.
Order 21 rule.
No.
You just now said that limitation applies.
Section 21. Section 21 of Limitation Act. I made
That-
a mistake. Section, I'm sorry, Millard, I made a mistake. So subtly, Millard, this also applies. Otherwise, if the Limitation Act does not apply to execution, then what happens? After 100 years, somebody will come and execute. Can't be, Millard, it's an absurd proposition of law. It's an absurd proposition of law. Now the question is, in Order 1, Rule 10, limitation applies or not? That is also stated in Order 1, Rule 10, Millard, Sub-Rule 5.
No, their proposition is that limitation, they do not say that Limitation Act does not apply to the execution cases. Limitation Act has to apply, otherwise 136 won't come in, and that entire article, set of articles regarding Limitation Act applies. Section 21, this mitigation given by Section 21 does not apply because of the language of Section 21, where after the institution of a suit, that is the language of 21. So although Limitation Act per se applies, the articles apply, but this particular section of the Limitation Act, like there are certain sections, say Section 5. Section 5 is not applicable to a suit, but
Original proceeding. Suit is the original proceeding. So
Yes.
Section 5 cannot take care of it.
so therefore there are provisions in the Limitation Act where Limitation Act, can you say Limitation Act does not apply to a suit? Definitely Limitation Act applies to the suit,
But not
But-
Section 5.
not Section 5.
Correct.
Similarly, they say that Section 21 is not applicable to execution case. Limitation Act as a whole applies definitely to execution. So they say because of the language of Section 21,
I will come.
which uses the expressions plaintiff, defendant, and suit, it does not apply to execution. That is their submission.
That principle will apply certainly. Millard. This principle will apply.
Hmm.
May not be in express terms,
Hmm.
but the principle will certainly apply. It's like, Millard, principles of analogous there too, Millard. Analogy has to be drawn, Millard.
Hmm.
May not be direct, but the analogy has to be drawn.
Hmm.
Now the question is,
Hmm.
this judgment, Millard, I found 2011 volume 3 CTC 632. This is that the Order 1 Rule 10 does not apply to, Millard, the execution proceedings. He argued that.
You may rely on Mr. Deb, Section 141 of the Code of Civil Procedure, which Mr. Gupta will also deal with in reply. So this is the court putting a question to you. Section 141 of the Code of Civil Procedure. Although mutatis mutandis is there,
Miscellaneous proceedings. The procedure provided in this court in regard to suit shall be followed as far as can be made in all proceedings.
so this also may be attracted,
Yes.
because this specifically says procedure provided in this code in regard to suits, which applies to Order 1, Order 22 all, shall be followed as far as it can be made applicable in all
In
proceedings.
all proceedings.
But as far as it can be made applicable,
Absolutely. As
they have
far
to
as
show why it cannot be applicable.
why it cannot be made applicable.
All right.
Why it cannot be made applicable. There has to be a logical.
Have you got a copy of your written notes of argument?
Yes, I have.
Hand it over so that I can take my notes on that.
Yes,
It
yes.
will be
Millard, I
easier
would-
for
I
me.
would.
Because your arguments, additional notes, I'll take on your note. That's my system.
They
If
would
they
wish
argue
to.
something additional, I'll add it to their
Additional
note.
thing, Millard, I have said it's an implied consent.
Whatever, I'll just put my notes on your notes regarding
Very
your
well,
argument.
Millard. Additional point, Millard, which possibly was not there.
Yes.
It's an implied consent, execution proceedings. They say, I was not served, one of the point, the execution application. They say implied consent all throughout you participated. And Order 21, Rule 22 says the court shall. So it can't be said because of this, the execution case is barred. You always had knowledge.
Plus Justice Bossak's order,
Yes,
which
yes,
your learned friend was kind enough to hand up.
absolutely.
I mean,
And that I have said in the note. That I have said in my note.
19th February. 19th
Yes.
February.
And Millard, the one judgment I want to show on this, Millard, 2021 Volume 3 CTC 632,
2011, sir.
2011. আমি খালি ভুল বলে দিচ্ছি। That was also. '81 Bombay, I think I had given to your lordship. I've got another copy. Lordship has taken note of this, no? 81 Bombay. I think I've given your lordship. Paragraph 6.
Yes, yes.
It's marked, my lord, but lordship can take this copy.
No, no,
I've got-
Mr.
Very good.
Well, you can hand over your copy.
Mark, that's why, my lord.
Mark, no difficulty. Easier
well, then
for me.
lordship take it.
Easier for me.
This
Right.
one, my lord, 2011, volume 3, CTC 632.
Mhm.
Our present Chief Justice, when sitting singly, my lord, delivered this. Facts are slightly different, but it says in no uncertain terms that Order 1, Rule 10, my lord, applies to execution also. It has to be because of 141 or whatever way, para 12 to 15. Para copy thing. Para 12 to 14. Therefore, in the present case, may I, my lord? Therefore, in the present case, we are faced with only one application for implement in the execution proceedings. Therefore, this court is required to examine whether such implement application in the light of the provision of Order 1, Rule 10 CPC and to see whether the petitioner herein is a proper and necessary party to execution proceedings. While the examining the said application, this court is given ample discretion to consider as to whether a party seeking implement is a necessary party. As noticed above, the contention of the petitioner itself is that the claim for equitable compensation is not covered under the decree. Even assuming but not admitting, without admitting that such claim is adjudicated by the executing court, and if the executing court comes to a conclusion that the first respondent is entitled to the said amount under the head equitable compensation, it goes without saying that the petitioner, who is the requisitioning body, shall be responsible for settling such claim, since the land in question was acquired for the purpose. Thus, by applying common law principle, the petitioner who may be called upon to settle a claim, definitely a proper necessary party in a proceeding. By impleading the petitioner, it serves more than one purpose. Finally, firstly, it affords an opportunity to the petitioner to put forth their contentions in the presence of the requisitioning body. Secondly, it gives a binding adjudication to the issue and would avoid multiplicity of it. It is sin in that regard. Then paragraph 15, minute, quote adds. It says that it applies. Kindly see it. Now, my lord, let me deal with the judgments, my lord. I don't have to add on this, my lord. And at section 21, I say it applies. May not be in direct terms, but the principles will certainly apply. 21.1, what lordship has recorded. But I'm not troubling your lordship again, because then again, lordship will be redeciding this issue. That can't be done in a review petition. At the outset, I said. Though the court has been troubled to decide it again by urging all points. Now, my lord, the judgment. May I, my lord, start with the judgment of the division bench presided over by Honorable Justice Bhaskar Bhattacharya, my lord, paragraphs 24 to 26.
Yes.
Much emphasis has been given about the what proceeding.
Yes.
What is suit and what is application? Paragraph 24 to 26 have been placed before your lordship, if I am not wrong, lord. The word application and suit had been defined in 2B and 2.1 of the Limitation Act. Application includes a petition. Suit does not include an appeal or an application. Both are the judicial proceeding. The proceeding refers to not only a complete remedy, but also to a step in the larger action of the. I'm not just placing it. Paragraph 26, if lordship kindly comes to. Following from the definition, it may safely be said that there are two broad categories of proceedings. First, a proceeding which is entirely course of action, and the second, a proceeding which is a step ancillary to or taken in course of the first. A suit is a complete or independent proceeding falling within the first class of the proceedings. Applications, according to the Limitation Act, are governed under Article 118 to 137. Characteristically, they are means the applications, with or ancillary to, kindly turns over, suit, its decree or execution.
Yes.
So, my contention is, if the application is treated, they're ancillary to what? He says, suit, that's the end of the matter. I say no, it can't be. It's a continuation, execution. Suit, it's decree. Naturally, suit finally has to be decree or execution. So what he tries to submit, the execution has been carved out. It's not the court never said that. Relying on to the provisions of Limitation Act, the court never said that.
All right.
Characteristically, the applications are in connection with or ancillary to what? To a suit, its decree or execution. Has to be, my lord, the execution has to be a continuation of that. What Lordship has said, not the Section 5 and applicability, it doesn't apply because suit is original proceeding. Appeal is a continuation of suit. Otherwise, why would this word suits in decrees or execution? That has been clarified.
That is in the context of application. An application can be filed in connection with.
Characteristically, they are.
Is the applications.
Applications, they are in connection with what? In connection with ancillary to, I think it refers to the first one, proceeding. First one. With
right,
ancillary, because it refers to suit.
All right.
Suit means the first one. This is what I subject to what falls from, I think.
So in this sentence, characteristically, they are in connection with or ancillary.
To
So
what?
here a distinction is made between applications on the one hand
Yes.
and suit, decree, and execution on the other.
Yes, that's what I want to
So
say.
they are put on the same bracket, suit and execution.
Yes, that is
An
what
application is something in connection with that.
Absolutely, my lord.
Execution is not an application as per this
No,
sentence.
exactly.
All right.
That is what I want to say.
Accepted. I mean,
Now, my lord, the next one.
accepted tentatively, subject to what Mr.
Yes, of course,
Yes.
Now, my lord, the other one. There are plenty, my lord. The judgments which he cited before and Lordship has dealt with, I will not again. Because then there's no point of
No.
re-arguing, re-agitating. Then again,
That have been dealt with in the main.
absolutely elaborately, with a reason. Now, my lord, the other one he cited on Order 1, Rule 10. 2004, Volume 1, APLJ 401. The execution petition
Yes, APL.
not applicable. Order 1 Rule 10 does not apply to execution. He cites that one.
Yes. So it's Hyderabad versus Madras.
Hyderabad was a Madras.
Because Justice Shivaganam's judgment you cited sitting in Madras High Court. Single.
But forget whether Hyderabad, Madras, Mumbai, everything. That's about the principle of
There's
law.
a conflict of decision at least.
Certainly, always.
Which always gives a court of some food for thought.
Absolutely, my lord.
Yes.
And to come to its own finding.
Yes.
And this is possibly, arguably, the best court, my lord, subject to what, my lord, I feel, my lord. Come to his own finding, my lord. But law is nothing but, my lord, it's original thinking, my lord. Noted down, written down, my lord. We have to find.
Particularly when the judge does not know the law.
No.
It's always original
Lord,
thinking.
that we can't say.
It's original thinking all the way.
With some respect, my lord, that we can't say when we address this court.
No, not that. But
Certainly, my lord. We always discuss
then
it in
it's
the parliament
creative
or-
writing and original thinking. When you don't,
But that's a
when you're
different.
not sure of the law.
But my lord, we always discuss it in the
No,
corridor
not
and
that.
everywhere.
Then let us forget. Yes.
No,
I
my lord.
withdraw that comment. Yes.
Now, my lord, this Order 1 Rule 10, my lord,
Yes.
there is a distinction if Lordship reads this judgment.
Yes.
Here, it's not about simplicity of simpliciter adding a party. Here, it's about protecting the interest sufficiently protected. One person missed out by mistake. And then in the execution, when benefit was taken, I missed it out. Upon being pointed out, I added. So this is the distinguishing feature if you may not consider this judgment. Straightway, somebody is not being added here. It's an award. You are a party. All were added. Your group. You say inseverable. Forget about the inseverability. You say your interest was not protected. Proved fully protected. Then a particular gentleman has been missed out who has been sufficiently protected. So this judgment doesn't apply. It doesn't discuss that. Simpliciter addition, yes. But when it's a deemed decree, you are a party, I will not be able to exercise when you point out. And for that, the execution goes. I am saying not only others, against you also it survives. Because of Article 136.
This was probably Hyderabad was probably a scenario where, under Order 21 Rule 99 and
Yes, yes.
because why I say this, because here an independent right was agitated, and on that plea probably he sought to be added. He was sought to be added.
Absolutely.
So therefore, court said that Order 1 Rule 10 you cannot add a new party seeking
No,
independent.
absolutely, my lord.
So there you have to come up under Rule
What is-
99 or 101 or
Third
whatever.
party multiplicity of
Third party
proceedings.
multi-
Yes, you can argue and ventilate your grievance because that will be a multiplicity.
Yes.
Absolutely, my lord.
Probably this was such a scenario. Anyway, we'll look into that.
Because then again, the court will be invited. Otherwise, a fresh suit.
Yes, there obviously Order 1 Rule 10 is not applicable because there is a specific provision for that.
Absolutely, my lord.
Very
Absolutely. Now, my lord, the other judgments which he has cited, my lord, some, my lord, factually not applicable, but I have taken note of it. I will deal with the. Basically, he harped on this too. One, he cited, my lord, 2000 SCC online Calcutta 388 2000 volume 2 CHN 640 equivalent.
Yes, Justice Rai, Ajaynath Rai.
This is, I have read it, my lord, the paragraph 144, 140. Facts are totally different. They are, my lord, negligence proved. If lordship sees there's an allegation of negligence proved, then where is the negligence here? It's a bona fide mistake. And you are prejudiced, suffered. No, you did not suffer. You did not even point out. No corrigendum to your, what should I say? It's a incorrect statement, frivolous, false statement. I do not know. When you come to court, you say 2014 X died. Writing letter, you says 2024. Just read this order. 2020, you don't even point out. So what is going through your mind? So it doesn't apply, my lord. Now, my lord, the other one, my lord, 2007, volume 11, SCC 407, paragraph 9 and 11.
Good faith.
Good faith. I say I have acted in good faith. It's a good faith. Absolutely. Paragraph 9 and 11. Where is the malafide on my part? Contrary, your malafide is proved. The two documents on record. 2024 X died. Then 2022 SCC online 1307. The necessary party, proper party,
22 SCC online. Let me find it.
2022 SCC online 1307, my lord, he, my lord, cited, my lord, presided over by Justice Gawai, my lord, on proper party and necessary party.
Yes, yes.
Now, my
Right.
lord, we are at the stage, my lord, of substitution.
Hmm.
One person left out. Again, if lordship reads the judgment, my lord, it's totally facts are different, my lord. No way it can be connected with our facts. Paragraph 14, 15, 16, my lord. No way it can be, my lord, equated with the case that we have. Here, the execution, my lord, award passed during, prior to execution, X passed away.
No, they say that that X was a necessary party in the execution case. For that, they have cited this.
Yes.
He had to be imputed.
That's right. I'm not doubting about that. I'm not doubting that he is not a necessary party. But the thing is, what is
But
the,
again, this was in connection with the suit. I mean, there arguably may be a scenario where the decree is severable. I choose not to execute against it against one. Can't there be? Unlike a suit. In a suit, I have to implicate all the necessary parties, whoever is affected.
absolutely.
But if I waive a benefit in an execution case, suppose I leave out a party, I waive my benefit against him, that can be done. So if that be so, this is not applicable. Suit scenario is not akin to execution in every respect.
No, not a key.
Cannot be superimposed.
No. But the principle, when there is no provision.
Necessary party,
Yes.
he was a necessary party if you want an execution against him.
Necessary party in the suit. Lordship is absolutely correct. Here, that part is gone. Now we are in the execution stage.
You may just choose not to execute the decree against him also, suppose.
Yes, but I'm not arguing.
But this is subject to their other argument. If I accept that, then this goes that it's inseverable.
Yes.
Very good.
I say even both ways you are out.
Yes. Yes.
Both ways.
Yes.
And 21 definitely applies, my lord. If Limitation Act applies, the 21 applies, and 141 Lordship has said, well, miscellaneous proceedings. Akin. There are certain things which we may not get directly, but we have to apply by applying the principles of analogous thereto or the analogy. And that while dealing with misconception of law, the Supreme Court has said.
But Section 21 does not come in by the route of order Section 141, because 141 says the provisions of this code will apply.
Code.
Section 21 you have to independently argue, Mr. Dev.
But I'm arguing, the Limitation Act applies. Limitation Act applies certainly. If the
Limitation Act applies, but as like the example I gave you, Section 5 is not applicable to suits.
Absolutely.
Although Limitation Act applies to suits.
Yes.
Similarly, Limitation Act applies to execution case, but Section 21 by its very language excludes it. That is their argument.
But they say, may I 21.1?
Yes, please.
Where after the institution of a suit, a new plaintiff or a defendant is substituted or added, the suit shall, as regards him, be deemed to have been instituted when he was so.
So by using the expression suit, plaintiff, and defendant, other proceedings are excluded. That is their argument.
No, my lord, my respectful submission would be no. Provided that where the court is satisfied that omission to include a plaintiff or the defendant was due to a mistake made in good faith, it may direct that the suit as regards the plaintiff or the defendant shall be deemed to have been instituted on earlier date. So, my lord, what I respectfully submit, my lord, my understanding is this particular provision, though it says suit, does not restrict to only suit for two reasons, my lord. Firstly, I say the execution is nothing but a continuation of a suit.
Have you put this in your written notes?
No, this part I haven't. This first time, my lord, is coming because Lordship has elaborately dealt with Section 21. So I, with greatest of respect, say re-arguing on 21 not permissible in review. Straightway you are out. If you consider Supreme Court, you are out just straightway.
So you say the principle should be borrowed to execution
Absolutely.
also because execution is a continuation of the suit.
Absolutely. And the other thing, my lord, what I say,
Yes.
other thing, otherwise say it's a section starts effect of substituting or adding a new plaintiff or defendant. Now, my lord, this has to be read with, my lord. This has to be read with, my lord. Order 1, Rule 10, it says proceedings. Three things, my lord, kindly consider. This is my understanding. Order 1, Rule 10, it says proceedings.
All right.
It says provisions of Limitation Act subject to Order 1, Rule 10(5). Now the applicability of 21.
So this is inextricably connected with Order 1, Rule 10.
Yes.
Because that is the only provision under which in a suit a plaintiff or defendant can be added.
Now the question is
That's a very interesting argument.
whether it's continuous or not, continuing or not, whether the execution is a continuation or not. If the court holds its continuation, proceedings mean execution, this will apply, my lord. Analogy will have to be applied. My understanding, my lord. Because I didn't find any other provision when somebody has acted bona fide.
Very good.
What happens? Forget about their acceptance and all that. Some sort of an analogy has to be, my lord, drawn, my lord, on this.
All right. Very good. So this we have to read Order 1 Rule 10 into Section 21.
Yes.
Because it speaks about addition or deletion of a party, addition of a party.
Yes.
Or substitution.
Yes.
So we have to read into this Order 22 as well as Order 1.
Yes. And also Section 41.
Substitution or added, substituted or added. Therefore.
Yes. Yes. And also Section 141. Why not the misleading?
Yes. If those come in, that is what
Yes,
I'm driving
yes,
at.
absolutely.
I mean, if those come in, then this
Yes.
also comes in.
Yes. Now, my lord, what happens in execution? Lordship would kindly see, just my lord, hypothetically. Forget about here. There.
Don't get so excited. Take your seat.
Forget about that.
You do this at home also. Whenever take your seat. Your turn will come, then
Forget about that acceptance. Ignore it. Nobody has accepted. Nobody. Accepting an order, it's an argument that I have. It's a good point. Forget about that for the time being.
Very good.
Just ignore it, that they have accepted it. Now, my lord,
Yes.
suit is decreed. All parties were made, my lord, not added in the execution. One has been left out by mistake. during the continuance, if it's not barred, because Article 136 says it's not barred, only provision which they say it applies an argument. I also
136 is there in your written notes.
absolutely it's there, is there. Now, my lord, then what happens? Will the case go? Will the entire execution will go as against that? 21 will have no implication.
Yes.
Suit, decree, and execution. What does it mean? Referring to Justice Bhaskar Bhattacharya's judgment, my lord.
Well,
Now, my lord, then 99 Calcutta, my lord, already lordship has dealt with, my lord. 60 Madras facts are totally different, my lord. Paragraph 9 they have referred to. There, my lord, is a death of a partner and it's a barred by limitation claim. 60 Madras they have cited. It's not a barred by limitation, I say. 60 Madras, Justice Ramaswamy's judgment.
those were cited at the at the
Then, my lord,
main
kindly
hearing.
ignore. Lordship
No,
has
no.
dealt with. Kindly ignore.
Review they have not cited.
Good faith I have dealt with. my lord.
60, I'm sorry. My mind. 60 address is there.
60 Madras.
It's 58 SCC online. That's why it
Three
is.
judgments they cited initially, my lord. Whether 60 is comes
60 Madras has been cited in connection with the review also. Yes.
with, then, my lord, I would not, my lord, trouble your lordship. It's about limitation. It doesn't apply. And if this has been dealt with, my lord, there's no point arguing it again. Then I will be arguing contrary to what I have started. My lord, this review is not meant. Though I even stick to this, whatever I've argued up to now, it's on fact. Can't be done in
So
review.
60 Madras you say has been dealt with in the parent order.
Supposing it's not, my lord, the paragraph 9, it talks about barred by limitation, death of a partner. Here, there is no question of any limitation. Paragraph 9, they have relied upon.
They relied on para 8 and 23 to 25.
Well, it's my note, it's paragraph 9, if lordship
No,
sees, my lord.
8 and 20.
Kindly have a
8,
look
9 also. 8, 9 and 23 to 20.
Can you have a look at, my lord, paragraph 9?
9 short for yes.
Yes.
That was the point for determination.
Yes, that has not been placed. Barred by limitation. Suit for dissolution of partnership.
Yes, barred by limitation.
And it's a suit. It's a suit.
Yes, suit.
It's the original proceeding. And the appeal fails. It's a suit.
A suit but barred by limitation. On that they're arguing that your execution is barred by limitation as exists. Anyway,
It's not an original proceeding. But the first principle is whether it's original proceeding is not.
Very
It
good.
can't be. Now, the other judgments, my lord, I have, my lord, dealt with, my lord. I have nothing more to add. বলেছি ওটা আপনি আসেননি বলেছি separate reference.
Yes.
And I said that there was a compromise, separate reference.
Compromise in a suit filed by them. And we, the things of the court, we settled.
That
On
also
that
I have said.
basis, award was passed.
That's zero award. Basically, zero award.
yes,
on
that is in connection with your argument under 136.
Yes.
So what remains is injunction.
Absolutely. It's not a monetary, it's not a
Money stage is over.
absolutely, my lord. Because the award says, if lordship sees, it's basically recording the settlement.
Yes.
You have to do this, I have to do this.
The rest has been done. That is more
It's
important.
been done.
The do this, do that included money also.
And the monetary component has been settled.
That is recorded in Justice Bossack's order of 19th something.
Well, 19. And also, I do not know whether by the division bench prior to that, my lord, by Justice Oshim Banerjee.
Yes, probably that. So it has
I
been
do not
held
know whether it has been
previously.
annexed.
Previously, it has been held that that monetary component has been satisfied.
Yes.
Because your execution case is on the premise that monetary component has been settled.
Yes, and running and continuing. Presently, we're not fulfilling, discharging our obligation. And that's why, my lord, lordship has said, while coming to the final finding, and rightly, my lord, the execution application has to be altered, and lordship has given us liberty.
Yes. Regarding the running component of it.
Yes. But these are my lord respectful submissions. My lord.
Very good. Yes.
No, I bolechi. I can show your lordship, my lord, the separate bills, but it does not require.
No, we cannot look into that.
I will not trouble your lordship.
Yes.
Come back on the next Friday. my lord.
Why? Mr. Gupta was there. Running to and fro.
I don't intend to dive into it.
Pardon?
These are waters that I don't intend to dive into alone, my lord.
Third learned counsel for the respondent in the review application, respondents in the review application. Full stop. On the prayer of learned counsel for the review applicants, the matter is adjourned till February 14, 2025 for rejoinder.
But only thing with regard to law, new facts, I hope.
No, don't bring it.
Then again, I have to.
No, don't.
Just on
This
the
will never end then.
14th.
That will ensure that you don't argue further. So should we keep it on the 21st?
21st,
Tell
because
14th
I
August?
don't know what they will be.
Tell me, yes.
Ideally, they could have very well. Maybe he's busy elsewhere. I can't.
21st is a larger bench reference.
Keep it on 14th.
14th.
But if they argue anything, Lordship will call upon I will address on 21st. If
14th.
This much, if a new fact is, then my learned junior will pray.
Somebody will be there, yes.
Yes. না 21 ওদের অসুবিধা হচ্ছে আমি বাইরে যাচ্ছি আবার 28
No, 14th.
Let it be on 14th.
Yes,
Let this be, because I have argued everything, nothing more to be argued.
Yes.
And if necessary, would you, Lordship would permit me to join
Yes.
virtually, if
Of course, always. It's always open in my court to appear virtually.
that we all know.
No difficulty,
we all know,
whatever.
May I request the 28th?
Subject to you being raised properly only.
May I request the 28th instead of the 14th?
No, 14th.
I'm given to
No.
Mr. Gupta.
Then you have to do it today.
No.
Sorry, no.
Very well, then
It
14th.
cannot go on forever. A review application cannot go on. 14th.
14th.
If he is not there, you have to
I shall.
have a conference and you will argue.
I shall.
Next.
I'm grateful, Thank you.
Extremely obliged.
Next.
My lord, I'm appearing for the respondent number 1. My lord, we filed 48 applications which Mr. Bachawat was arguing for respondent number 2. My lord,
Matter is being dragged for a long time.
my lord, subsequently we had for respondent number 1, we had filed an application for deletion, my lord, which was rejected on 28th
Yes.
December. My lord, we filed a review application from the same, my lord. My lord,
No, this cannot go on. I mean, this will take forever. Then this execution will
my
never
lord,
happen.
once the review,
This is the reason Indian courts are being blamed by the foreign jurisdictions.
my
That
lord,
we go on forever and ever and ever and again. No further time. You cannot file every order will pass, then you'll file a review application and this execution will never happen. These foreign awards have to be executed quickly. That's the purpose of the statute and we have to do that. The Indian courts have an image to portray also to foreign jurisdictions, which is being ridiculed now because of these things, precisely these exercises. No, we cannot adjourn the matter. You start argument.
my lord, then kindly grant us-
Adjournment was sought. You are respondent number 2.
my lord, I'm for respondent number 1, my lord.
Respondent number 2 seeks on 2 occasions, prior 2 occasions. Now 1 is seeking adjournment. Then I'll let it go out of the list. Today, when the matter is called on for hearing, an adjournment is sought on behalf of respondent number 1. Full stop. I find from the previous orders that on January 17, 2025 and January 31, 2025, adjournments were sought on behalf of the respondent number 2. Full stop. It is absurd that an execution proceeding is going on for so long unnecessarily due to adjournments being sought by the parties. Full stop. As a last chance to the parties to make their respective arguments, the matter is adjourned till February 14, 2025. Full stop. It is made clear that in the event no arguments are advanced on the next date, appropriate orders may be passed by the court expertise.
My lord,
Your lordship, if I may make a submission, I'm appearing for the petitioner in this case.
my lord, one request, my lord.
Next matter, please.
Your lordship, am I audible?
You're audible, but I have already finished my order. Yes.
Your lordship, just one suggestion I wanted to make.
Yes. What is the suggestion?
Because since they have taken multiple adjournments and this matter is being dragged on by them, if the remainder of their submissions they could make by way of in writing, maybe that could save the court's time.
Of course they can.
And if
can
there is any
directly-
future adjournment, your lordship,
Yes,
then
you're
costs may
absolutely
be
right.
imposed.
I'll do that precisely on the next occasion. I haven't spelled it out in my order. But if this happens
Grateful.
on and on, then I'll take written notes of arguments and conclude the hearing.
Grateful,
You're
your lordship.
absolutely right. You're Mr. I can't see your name because of my...
Siddhant Bajaj.
Yes, Mr. Bajaj, you're right.
Grateful, your lordship.
Yes. Yes.
7, my lord, I appear for the petition.
For the respondent, my senior, Mr. Jishnu Shah, is on his legs in court number 36.
No, let us start the hearing. Yes.
I'm praying for a short
No, no,
pause.
refuse. Yes, start the.
My lord, we had concluded our submissions. My
Then
lord.
I'll close arguments.
Just one.
No, we'll close arguments. So you have to come prepared with the matter.
Lordship, then if you can give me just 2 minutes, I'll just bring in my files and
No. You don't have your files even.
Lordship, just right here. Actually, I was waiting for my senior to come and start. Lordship.
Well, I'll take that break now then. Okay, take it. Raje, Rake, Taka, I'll take that break in the Yes. Continue. Yes, please.
Lordship, at the outset, I say Mr. Jishnu Shah is leading this matter. He is in another court. He'll be coming. So, as your Lordship has been pleased to direct me, so I
The idea was to make her start, not you.
my apologies. Then let her start. You see what happened, Lordship? He always with me, and I allow them to start.
That is precisely what is the intention of the court
Exactly.
also.
But
So
now,
otherwise, they'll never become prepared.
that's
They'll
it.
ever be under your umbrella.
That is true. At the same time, I am now under umbrella of Mr. Shah.
Understood, but let her start.
Okay. Lordship, what has happened? I just, the entire,
No, she has to start.
he probably is not ready with this matter.
Very well, you can start.
Lordship, kindly
Very well.
apologize. Okay. Now, Lordship,
No difficulty, then I will adjourn the matter. Because you are competent to start. It's the juniors who are to be prepared. We don't have any doubt about your competence to start. She is also competent, but she has to prove her competence as yet before courts of law.
okay.
Your competence is not in doubt.
Now, what happens a long time?
So we'll grant a time for Mr. Shah. Very well. You are for the respondent, right?
Lordship.
On the prayer of the respondent, the matter is adjourned for the day. Come back on next Friday. Yes. Eight to 10 together, 8 to 11.
The application under section 34.
All right.
And two applications where we are seeking stay of the award under section 36 because it involves grounds of fraud. So
we'll take up the 34 itself.
Yes, of course. Your Lordship, kindly.
You are for the other side,
been,
Mr. Ghosh? Yes. Don't go get so close.
Otherwise, also you're too close.
Otherwise, you are close. Don't make it very obvious. Right. No, it's all right. Please continue. Don't mind my comments.
Absolutely.
I'll desist myself from making these comments in court now.
But on a Friday, afternoon, it is, yes.
Because on the library is even worse.
No, obviously, I miss the days in my association also. Anyway, yes.
The petitioner before your Lordship, now is under after the approval of the resolution plan. This perhaps I have to give your Lordship a brief history. This has been argued before your Lordship by Mr. Joyanto Mitra and Mr. S.N. Mukherjee and Mr. Bachawat, Mr. Ranjan Bachawat was there on the other side. And Mr. Joyanto Mitra and Mr. Tilak Bose was there leading me in this matter.
Yes.
This is a matter where an award or rather two awards in both section 34 applications, two awards have been I wouldn't say served on us, was disclosed for the first time in a parallel collateral proceeding in before the National Company Law Tribunal. We receive it for the first time, and we find that two nil awards have been passed, where after receiving those really the opposition to the section 7 application which was filed before the National Company Law Tribunal, we come to know, we immediately
This is your argument on limitation.
No, I am not. I'm just giving
How
a
is that
brief
German?
overview.
I mean, you came to know for the first time. How is that German?
German because of the fact that they have taken a point of limitation. That
That's what I'm saying.
Yes,
this is your
I
submission.
have not been served with the award yet.
All
So
right.
your accrual of cause of action to file a objection on a section 34
Has not commenced yet.
has not commenced yet.
Right.
So I'll place judgments. I believe judgments have been placed also. But be that as it may, briefly to summarize what has been argued before your Lordship.
Yes.
Because it's been very long since the arguments were made.
Yes.
If I may indicate from if your Lordship kindly takes AP 530 of 2024.
Yes.
Firstly, who is the petitioner? The petitioner was as your Lordship can get from the name, was Shrey. Initially, it was being represented by the administrator, who was appointed by the Reserve Bank of India after it superseded its board of management. by virtue of operation of law under sections 45 IE of the Reserve Bank of India Act. And thereafter, my lord, an application was filed under section 227 of the Insolvency and Bankruptcy Code, my lord, before the National Company Law Tribunal, where, my lord, corporate insolvency resolution process was initiated against, my lord, Shrey. My lord, the resolution plan was subsequently approved, my lord, on, my lord, 8th of October 2021, and, my lord, I'm sorry, 11th of August 2023, and, my lord, after, my lord, resolution plan being approved, my lord, the company, my lord, is now been, my lord, taken over by a consortium of banks, nationalized banks, which is, my lord, being, my lord, named as NARCIL, National Asset Reconstruction Company. Now, my lord, this is, my lord, the brief background so far as the petitioner is concerned. Now, so far as, my lord, the transaction is concerned, my lord, the petitioner, my lord, by way of, my lord, several agreements, my lord, the subject matter of dispute, my lord, in this is, my lord, 2 agreements where, my lord, 2 section 34s are, my lord, pending. My lord, the 4 agreements had given loan to, my lord, the respondent, and, my lord, those loan were in default. So, my lord, the petitioner in the section 7 application had sought for, my lord, recovery of, my lord, the loan amount, or, my lord, corporate insolvency resolution process in respect of, my lord, the respondent company, because they were in default on payment of the loan. My lord, for the first time, my lord, this, my lord, award, the impugned award, if I may use the word, was disclosed in the objection filed to the section 7 application. My lord, that was, my lord, made available, my lord, the section 7
IBC.
Yeah, of the IBC, I'm sorry, of the Insolvency and Bankruptcy Code. That was, my lord, filed on, my lord, 25th of January 2024, and, my lord, immediately thereafter, my lord, the award, my lord, we came to know, my lord, I'm sorry, my lord, the date of knowledge is, my lord, 25th of January 2024. 25th of January 2024 was, my lord, the date of knowledge of the award.
From that affidavit in opposition.
From the affidavit in opposition filed to, my lord, the section 7 application. And from there, my lord, we, my lord, counted our, my lord, the stipulated period, and we have filed it within the stipulated period. Now, my lord, from the award, my lord, what is, my lord, evident is, my lord, that the parties, my lord, have, my lord, never, my lord, gone ahead and, my lord, was involved in any arbitral proceedings. My lord, there is, my lord, no notice. My lord, there are no documents before your lordship. Neither has it been disclosed, my lord, the respondent, that what are the documents which were there before the learned arbitrator. My lord, there is no statement of claim. There is no, my lord, statement of defense. My lord, though, my lord, the arbitral award, my lord, surprisingly proceeds on the basis that there is a reference, my lord, section 21 notice under the Arbitration Conciliation Act given, my lord, by the petitioner, the claimant. And, my lord, the section 21 notice had been, my lord, thereafter, my lord, accepted, and, my lord, a reference had been, my lord,
You deny everything from section 21 stage up to the award.
Up to the award.
You had no knowledge.
I had no knowledge. My advocate on record, whose name is recorded in the Mr. Oyan Chakraborty, is, my lord, I have to take the name because it's also recorded, my lord, in the award, have given a specific letter that I was never involved with any arbitral proceedings before.
This is a part of your affidavit. Yeah.
This is part of my affidavit. They have, my lord, not disclosed any documents in, my lord, support of, my lord, their contention that, my lord, the arbitral reference had taken place. There was a statement of claim filed. Evidence had been led, my lord. All this is part of the award, that evidence had been led, and thereafter, my lord, an award had been passed. Surprisingly, my lord, a lot of, my lord, if I use the words, my lord, patent illegality is there, apparent from the award itself. If your lordship kindly permits me, my lord, I shall, my lord, go through, my lord, them, my lord, one by one. Your lordship kindly takes, my lord, page.
It was a common award, common judgment sort of in.
No, my lord, there are, my lord, separate awards, my lord, both nil award given by the learned arbitrator. Lord, just prior to, my lord, going into the award, my lord, I would also like to, my lord, place on record, my lord, the correspondence, my lord, which had been exchanged with the, my lord, learned arbitrator as soon as we got to know, my lord, there is an award. which we got to know from the affidavit in opposition filed to the Section 7 application before the National Company Law Tribunal. If your lordship kindly takes those
In the affidavit in
correspondence.
opposition, was a copy of the award also annexed?
No, only only a photocopy of the award was annexed in the affidavit in opposition. But I shall go through the annexure as well. Your lordship takes
Yes.
kindly bears with me for a moment.
Yes.
I'm showing it from 530. Your lordship kindly takes AP 530. Page 323 at volume 3 of the petition.
Yes.
We are representing Shrey Equipment Finance Limited. One of the borrowers of our client, namely Road Wings, is in default and proceedings have been initiated under Section 7 of the Insolvency and Bankruptcy Code. The borrower has filed a reply thereto and has disclosed 2 awards dated 17 September 2020 and 21st September 2020, which is stated to have been published by you. For your reference, copies of such awards are enclosed herewith. Since our client has undergone CIRP and there is a change of management, upon such awards being disclosed in the reply affidavit by the borrower, a thorough check has to be conducted by our client, but no records of such arbitral proceedings could be found. In such circumstances, on behalf of our client, we hereby request you to kindly provide us with a complete set of the entire arbitral proceedings culminating in the aforesaid 2 awards relied upon by the said borrower. Now, if your lordship kindly takes, the awards have been annexed thereafter as an enclosure to that letter. Now,
Did the arbitrator reply?
Yes, I'm placing the reply of the learned arbitrator. Lordship kindly takes page 345.
Yes.
Says, this has reference, this subject is arbitration between such and such. This has reference to your letter dated 1st of March 2024 received by me on such and such, wherein you sought certain details on behalf of your client. In the said matter, I have passed an award dated 17 September 2020 and 21st September 2020, in which it may be noted that the following charges as detailed below are pending from your client, Shrey Equipment Finance Limited. Then the award dated 17 September 2020 and award dated 21st September 2020 has been the details of the arbitral fees, the claim amount, and conveyancing secretarial charges, etc. had been detailed. And finally, kindly turns over the page 346 says that the aforementioned fee and other charges totaling to 11 lakh and odd may kindly be deposited by your client in the favor. Bank details have been given. And thereafter it says that your client has been advised to deposit the amount within a week so that necessary reply can be given. So we get this reply as an answer to detailed query. Thereafter, page kindly turns over to page 348. We are in receipt of your letter dated March 5, 2024 and forwarded the same to our client for instructions. Upon receipt of instructions, we are writing this letter to you. Our client has undergone, we again reiterate that we have undergone a CIRP and there's a change of management. Thereafter, if your lordship kindly takes paragraph 4, we go ahead and we give that while the new management of our client is now in process of looking into the records, our client kindly requests you to provide us the following. So we ask them for the Aadhaar card, PAN card, cross or cancel check, along with the minutes of the meeting wherein fees of the arbitrators have been determined, along with the letter appointing the learned arbitrator as the arbitrator in the matter. And thereafter, we ask them to, my lord, ask her to, my lord, aforesaid documents will enable our client to look into the matter and take expeditious steps. To this, my lord, she replies at, my lord, page 350. I acknowledge the receipt of your letter dated 11th March 2024, bearing reference number such and such. I write to bring to your attention that the outstanding fees and charges of 11 lakhs, which remain unpaid despite my prior communication. On 5th March 2024, I provided my bank details for the purpose of remittance with a copy furnished to your client, such and such. In light of the aforementioned, I request you to expedite the payment process with your client. It is imperative that this matter is resolved prior to any further correspondence regarding the arbitral award dated such and such and such and such between such and such, wherein I have become functus officio after passing the awards and returned all documents to the parties concerned, retaining the original awards with me. So, my lord, documents were not
When the
provided.
award was passed and during the pendency of the arbitral proceedings, Shrey was not in insolvency.
Shrey was.
Was.
My lord, when the arbitral award was passed, no, I'm so sorry, my lord. The arbitral award was, my lord, passed, my lord, in 2020. Arbitral award was
Before
passed in 2020.
all this happened.
Yes. My lord, the supersession of board, my lord, happened on, my lord, 4th October 2021 by the, my lord, Reserve Bank of
So
India.
at the relevant juncture during the arbitral proceeding, so-called arbitral proceeding and the award,
yes,
Shrey was in charge of affairs.
Prior management was in charge
Prior
of
management
Shrey.
was in charge.
Prior management was in charge of Shrey, and hence, my lord, we have very candidly, my lord, written all those letters that we do not know. We do not know. You please tell us if there is an award like that.
Yes.
But to our reply and to our, my lord, disappointment, my lord, that nothing was provided to us so far as, my lord, the pleadings are concerned.
Bank
even
details were provided.
Bank details were provided. Yes, of course. Now, my lord, to this, my lord, if your lordship, my lord, now, my lord, kindly takes, my lord, the awards. My lord, really, my lord, the awards would, my lord, speak for itself, my lord, how they have been, my lord, passed. Your lordship, my lord, kindly takes kindly gives me a minute, my lord.
Page 302 is the award.
Yes, my lord, page 302.
Annex to your letter.
I'll just, my lord, try and find out, my lord, where I have marked it, my lord. Kindly gives me one.
Yes, yes, absolutely.
Your lordship, my lord, kindly takes page 334 of, my lord, AP 530. Perhaps your lordship was not looking at, my lord, 529. That's why perhaps your lordship has marked, my lord, 529. My lord, I also see that 529 was marked. Was 529 being argued initially?
AP 529.
529. Perhaps your lordship has, my lord, marked 529.
Maybe.
That's why perhaps, my lord, your lordship
I'm
is
not finding
my lord,
nothing here.
finding any, my lord,
Marking.
yes, my lord.
এটা থাক এক্ষুনি সরিয়ে দিও না Yes, you're right.
My lord, may I, my lord, shift to, my lord, 529? I'm
Please
so
do.
sorry, my lord.
Please do.
Should have started with 529. Well, it's really, my lord, the same.
Same.
Documents are also same, but my lord, yes, my lord, it's been marked at 529. Now, if your lordship kindly takes, my lord, the third volume, page 315. Hmm. 529. I'm shifting to 529.
Page 291 it starts in 529. At page 291.
Yes, my lord, it's been annexed, my lord. Yes, my lord, you can lordship can my lord, look at from my lord.
Oh, 315 also, yes.
Yes, my lord. Same, my lord.
Several times over. You can refer to the internal pages also if you. There
Yes,
are.
my lord. I'll my lord, refer to the internal pages. My lord.
Are there internal
my lord, both
pages?
the awards, my lord, one by one
There
after
are
the
no
other.
internal pages probably. I don't find any internal pages also. You can refer to the.
It's really my lord, small, my lord, towards the bottom of the page, right hand corner. But my lord, I would not like to my lord,
Oh
trouble
yes,
your
yes,
lordship.
it is there. It is there. You can refer to the paragraphs also.
Yes, my lord, I will.
Yes.
If your lordship, my lord, kindly takes my lord the award, my lord, which is my lord dated. I'll tell your lordship, my lord. Dated my lord 17th of September 2020. That's the my lord first award.
17th of September.
That's my lord towards the my lord, the end
Yes,
of
yes,
my lord,
yes,
the
yes, right, right. Yes.
My lord, it goes on, my lord, saying, my lord, I, Bandana Rai, former district and session judge, appointed as the sole arbitrator jointly by the claimant and the respondent. With its reference letter dated 29th December 2019 in pursuance of an arbitration clause contained in an agreement dated such and such, executed between the claimant and the respondent. So, my lord, it talks about a reference letter.
You admit up to the existence of this agreement.
Agreement, yes.
Up to that.
Yes.
Nothing else happened regarding
Nothing else happened after that. Now, if a lordship, my lord, kindly turns over the page and my lord takes my lord paragraph 2 of the award. It goes on to, my lord, say that I have carefully considered and gone through the pleadings, submissions, arguments of the claimant. So, claimant apparently is, my lord, the petitioner before your lordship, my lord, Shrey. Documents on record on behalf of the claimant, case laws cited on behalf of the claimant and respondent.
So they come in only for the case law, as per this.
Yes.
Pleading submissions and arguments.
Arguments for the claimant, yes.
Anyway.
Thereafter, Mulad talks about Mulad paragraph 3 that she proceeds to Mulad make this award. Mulad kindly takes Mulad paragraph 4. The claim petition has been signed by the authorized person of the claimant, and he has been duly authorized to institute, sign, and verify the statement of claim and do all other acts, deeds, things necessary for a proper adjudication of the case. We read the letter of authority of the claimant, which is annexed to the claim petition filed by the claimant. But I will, Mulad, make my comments, Mulad, towards the end of the Mulad, after going through the award. If your lordship now
You don't have a copy of anything. I mean, claim petition, nothing of
nothing, Mulad. We sought for everything, and Mulad,
where affidavits directed in this.
Yes, Mulad, affidavits had been.
They have
filed.
disclosed claim petition.
They have not disclosed anything.
Why waste time? If you can't also, if you also can't produce a claim petition or any of the pleadings, then let us have it over. I mean, done with, and let us set aside the award and just. Very well. Yes.
Now, Mulad, paragraph 6. Mulad, it talks towards Mulad. I will not trouble your lordship to go through the entirety of the award. Paragraph 6 of the award, towards the middle of Mulad, the paragraph, where Mulad, the sentence starts with Mulad, 6th line from the end of the paragraph.
This paragraph?
Paragraph 6.
Yes.
Mulad, 6th line from the Mulad, end of the paragraph, starting a sentence starting with accordingly the claimant through.
Yes.
Accordingly, the claimant through its lawyer, Mr. Oyan Chakraborty, with his letter dated such and such, stated that in view of the failure on the part of the respondent to clear dues of the said sum in spite of repeated reminders by the claimant as per the terms and conditions of the said agreement, and therefore on behalf of his client hereby determine and terminate the said agreement. So Mulad goes on to the merits of the matter that Mr. Oyan Chakraborty, being the learned advocate for the Mulad claimant, had Mulad made such submissions by his letter dated such and such.
Was there any collateral other proceeding, section 9 or anything of that?
Yes, Mulad, what happened is initially, Mulad, that is also Mulad very Mulad peculiar.
Yes.
A section 9 application was filed by us. And Mulad, that was Mulad by, I wouldn't say Mulad by us, by the previous management. A section 9 application was filed.
Shrey filed?
Shrey filed it. The previous management, Shrey filed it. Now Mulad, and Mulad, suddenly Mulad, a letter was disclosed by the respondent whereby Mulad, certain securities by way of Mulad, these are equipments Mulad, really, for which the loan had been granted. Certain equipments which were there, they said that this can be used for sale of these equipments and the loan can be repaid off. And my lord, that on the basis of that letter, section 9 was my lord withdrawn. The section 9 petition.
That
was
letter is
withdrawn.
on record in the section 9 proceeding.
The letter is my lord,
It was recorded in the order passed under
it was
section 9.
recorded in the order passed. I have those.
That is
orders.
also part of this.
Part of this, my lord. I shall go through my lord, the section 9 my lord, order as well as my lord, the letter referred to.
So there probably might not have been any occasion to refer the matter to arbitration at all.
Yes. Yes.
All right.
Which is why, my lord, the entire my lord, situation my lord, came as a shock to us because my lord, suddenly my lord, we came to know that there is an arbitral award. Now, my lord, kindly takes my lord, paragraph 10. Says that my lord, there were my lord, elaborate my lord, oral and written arguments made by my lord, the respondent. Now, my lord, kindly my lord, also considers this is an award which has been passed amidst my lord, where my lord, COVID-19 pandemic was very much prevalent. On 17th of September 2020, she says that this award has been published. So there were my lord, oral and written arguments which were my lord, there by the respondent. Now, my lord, kindly sees paragraph my lord, 10, my lord, towards my lord, end of paragraph 10, the my lord, sentence starting with the loan amount which got disbursed under this loan agreement and the amount that is actually received by the respondent from the claimant as per the books of accounts is only 57,25,951. Now, I'm not pausing here for a moment, my lord, why I placed this paragraph. My lord, despite this nil award, the respondent in its letter, subsequent to all of this, much more subsequent to all of this in the year 2023-24, have admitted there are still dues pending from the respondent payable to the claimant.
Under the same contract?
Under the same contract. So, my lord, this entire award, the dues, what have been stated in my lord, various paragraphs of my lord, the award. Now, my lord, kindly takes my lord, paragraph 13 thereafter, that the respondent had surrendered the hypothecated assets, reach stacker machine to the claimant on 8th March 2020. The claimant has got the machine value through their approved valuer who has valued the machine at 75 lakhs as on 8th March 2020. Now, my lord, we do not know the valuer.
This is contemporaneous with your section 9 order.
This is contemporaneous with.
So this might be a reference to that.
Yes, my lord, I'll just my lord, tell your lordship. Kindly gives me one moment. This is, my lord. This is. But, my lord, who did the valuation? Where is the valuation report? How is this being adjusted against the 75 lakhs which has been valued of those hypothecated assets? We do not know anything of that sort. Now, my lord, kindly takes, my lord, paragraph, my lord, 16, a contradictory stand. The claimant company issued a letter to me, thereby nominating me as the sole arbitrator.
So not jointly.
To adjudicate upon and decide the dispute of claim made by the claimant against the respondent and asked for my concurrence to act as the sole arbitrator in terms of the loan agreement. The respondent duly consented to my appointed of a sole arbitrator. I accepted my appointed and
may not be so contradictory, may be unhappy language. I mean, you nominated, they consented. And she says in the first sentence, jointly
referred by reference letter dated 29th December 2019.
Right.
Joint reference.
Right. Reference letter is joint. Yes.
All right. For adjudication of the dispute having arisen between the parties. Now, if a lordship, my lord, kindly takes, my lord, thereafter, my lord, from paragraph 18 onwards, she starts deciding the claim amount, my lord. So, recovery of 1 crore 89 lakhs and odd. Lordship kindly takes, my lord, paragraph 3 of, my lord, after, my lord, paragraph 8, the sub paragraph 3 of paragraph 18.
The learned counsel for the claimant has submitted that the outstanding amount has been calculated after giving adjustment and credit of the part payments made by the respondent from time to time. We do not know really the part payments made by the respondent.
In the previous paragraph, she states that you placed on record a copy of a statement of account of the loan account.
Yes, that also we do not know, because if this had been true, immediately thereafter, after this, I shall show the letters whereby the respondent concurs that there are still dues and payable of the same amount to the.
The amount also tallies.
The amount tallies.
Okay.
Now, kindly sees paragraph 8 of part of paragraph 18. I find that it is evident from the above facts and records that by both the parties, and even though the claimant has sanctioned an amount of rupees 1,89,88,100 towards the loan agreement dated such and such, the respondent been, however, disbursed only a sum of 57 lakhs by the claimant, which is received by the respondent and reflected in the books of accounts presented by both the parties. As your lordship was pointing out, yes, we had presented certain statement of account present by both the parties. This has been accepted by the claimant. So once she says that it's been presented by both the parties, then she says that it's been accepted by the claimant, and thereafter goes on to pass a nil award. Now, if your lordship now takes the second award is also really a verbatim copy of the award that I have shown to your lordship.
Second award means in the other matter.
The other matter, yes. So, if your lordship
dates are also same.
No, dates of the award is 21st of September 2020. Dates are definitely a bit different here and there.
The amounts are also different.
Amounts are
contract is also different. Different contract.
Yes, sir.
Very.
So, if
but they are also the same refrain. I mean, that there was a joint reference.
Joint reference.
Everything else is same.
Yes, rest of the language is same.
All right.
But I shall go through the second also to my satisfaction so that the same can be placed before your lordship. Now,
yes.
The first thing kindly takes page.
Ayan Chakravarti's letter he disowns.
Yes.
Next page, 301. Something else. No, not there.
No, it's looking at
the very next page of after the award, which
yes,
you placed.
301. Yes.
No, this is a claim made through Ayan Chakravarti by you apparently.
Yes.
Why have you annexed this? I mean, what is that?
This is what really is this is prior to filing of this is what really they had harped on initially, that this was being made, this claim was being made, this demand was being made, and hence because of this demand I have given you these are my answers to your demand. This is why they have annexed this. Now kindly takes Ayan Chakraborty's letter subsequent to our inquiry, which we have annexed. Page 85 of the supplementary affidavit.
আচ্ছা এক কাজ করো 5:30 টা এখন সরিয়েই দাও তাহলে 85 you said.
No, 529 is not 85. Kindly give me one.
Oh, acha. You are ready on 5:30.
I am on 5:30. I am sorry,
This is a letter by whom? Ayan
Chakraborty. Yes, kindly give me one more.
Yes. Try to find out here. Yes, my lord. If your lordship kindly takes page 103 of the supplementary affidavit, 529 AP 529.
Yes, 103.
Lordship will find, my lord, the date is, my lord, 30th of April 2024. So, my lord, this is after, my lord, filing, my lord. I have perused your email dated 22nd April 2024. To the best of my knowledge and upon reviewing my records, I certify that no reference has ever been made involving contract numbers 138524, 130853 and 138748. Those are, my lord, the, my lord, 138524 is, my lord, the contract, my lord, which is, my lord, 529 of the borrower Roadwings International Private Limited, as well as that I have never taken part in any arbitration proceedings regarding the above referred borrower and contract numbers before Honorable Justice. Now, if your lordship, my lord, your lordship's query was, my lord, what happened in the section 9 applications? My lord, the orders have been annexed, my lord, page 100 and 101, 102. Two orders in the past in the section 9 application. But we have disclosed everything. We have, my lord, because of, my lord, the fact that there has been a lot of, my lord, murky waters, we have, my lord, come clean so far as, my lord, whatever was there in our records after the new management, my lord, had come in, whatever was there in our records, we had to, my lord, come clean. My lord, page 100 is, my lord, the section 9 application. 529. In this application under section 9 of, my lord, the Arbitration Conciliation Act, as amended by Act 3 of 2016, the petitioner has prayed for appointment of receiver to take possession of the hypothecated asset on the ground of default in payment made by the respondent number 1. This is in, my lord, 17th of July 2018. Mr. Indradeep Basu, learned counsel, appearing for the respondent number 1, produced an electronic mail dated July 16, 2018, wherein it appears that the respondent wishes to make over possession of the hypothecated asset to the petitioner, and a copy of the said electronic mail dated July 16, 2018 be kept on record. In view of the above submissions made on behalf of the respondent number 1, hearing of this application is adjourned for a period of 3 weeks. Now, if your lordship kindly takes one of the next, my lord, order. Surprisingly, my lord, 14th August 2018, just, my lord, a month after, it is submitted by Mr. Banerjee, learned advocate, appearing for the petitioner, that the petitioner does not wish to press this application. AP stands dismissed as not pressed.
So is it your case that the possession was never handed over?
No, my lord, we really.
So if that, unless that be
No.
so, then it's contradictory to say that subsequently they had admitted the same claims by their letters.
It is, my lord, really a hypothecated, my lord, equipments which were, my lord, purchased by, my lord, the respondent for them with the money, my lord, provided to them by way of loan agreement. That they said that, my lord, because after selling of those, we have these hypothecated. This is the letter, my lord.
But as it appears from the section 9 orders,
yes,
the entire claim was settled between you by their agreeing to the hypothecated assets being taken over by you.
But the section 9 was only withdrawn. That will not, my lord, tantamount to, my lord, settlement of the claim.
Not that.
Because it's an interim, my lord, really measure, my lord, where, my lord,
very well.
So, my lord, there is no ground of, my lord, any settlement which was, my lord, ever recorded between the parties. But be that as it may, my lord, we are still, my lord, in my lord, anticipation, or my lord, we really do not know why, my lord, this was, my lord, withdrawn, despite the fact that this, my lord, hypothecated goods, my lord, would never meet, my lord, the loan amount, whatever is there. Now, my lord, now if your lordship, my lord, takes in the supplementary affidavit only, we have, my lord, disclosed, my lord, letters which clearly goes on to show that, my lord, dues was still pending. But I'm being led by, my lord.
Yes. No, Mr. No, your client is in able hands, still you came. No difficulty.
Grateful.
Yes.
Now, my lord, if your lordship, my lord, now takes, my lord, the supplementary affidavit, we have disclosed a series of correspondence which are subsequent to, my lord, passing of the alleged award.
Page 104 onwards.
104 onwards. Now, if your lordship kindly sees page 104 first, this has reference. This is a letter which has been written by the petitioner to the respondent. It's of 20th September 2022. It says, this has reference to your letter dated 16 July 2022. We state that the said letters were nothing but shows your malafide intention to dispute the outstanding dues. the contract number 17066 was booked in the month of such and such, amount was disbursed on such and such. The said amounts paid by you with the instrument dated such and such was adjusted in the following contract numbers. So we give them details that how this contract numbers. Now your lordship will find in the table which is given below, the first table appearing in the letter, your lordship will find the contract number 130853, which is the concerned contract number in 529.
And in 530, the other one, 133794.
I'm great.
Because you pointed out on the last occasion. Very well.
Now, 105, it says, case referred by you under contract 138478 is settled through Loka Adalat. The said case is still live and there is no payment from your end. So this is another contract. I'll not trouble your lordship with that. Furthermore, it is also to bring to your notice that the loans were disbursed after execution of the necessary loan document, which includes loan documents such and such. Please find the outstanding position of road wings as on 30th of June 2022. So we write to them, we say that nothing was settled. This is the amounts which is due. This is in 2022. Now, if a lordship kindly sees the reply at page 107, which is very interesting. Letter is dated 7th of October 2022. Both the awards are of 2020. 7th of October 2022, the respondent writes to us.
To the administrator. At that point of time, you are under this proceeding.
Yes. By that time, we were under 2021. The board was superseded by RBI.
Right.
And by that time, we were under the insolvency resolution.
Yes.
But as an administrator, we hope and trust that you will view the entire situation neutrally and without any bias. Thereafter, the word malafide intention as stated in Shrey's letter appears inappropriate. As you are aware that Shrey has been caught red-handed in various scams and therefore their version doesn't deserve to be blindly trusted. In reply to the contents of your letter, kindly note that there is no link between Roadwings International Private Limited and Highway Red Line Section, and it is not an economic entity formed of a set of companies, which is either companies controlled by the same company or the controlling company itself. The director shareholders of both the companies are different set of. This is really they want to wriggle out of the liability so far as the other company is concerned. I am not troubling your lordship with that. Kindly takes the paragraph starting with as regards other contents of your letter. As regards other contents of your letter, we have already surrendered all the assets and have already explained our position via our letter dated 16th July 2022, copies of which are again enclosed for your ready reference. I'll come to this later. Now, if your lordship takes page 108, the annexures B to F, if I may read. In your letter dated 9th June 2021, you have claimed an amount of 1,28 lakhs and odd towards contract number 133794. Subsequently, on 20th October 2021, the figure has been changed to 75 lakhs 22,833. This is not part of the award, but I shall indicate where it comes to the part of the award. In your letter dated 9th June 2021, you have earlier claimed an amount of rupees 1,51 lakhs towards contract number 130583, which is not part of the award. But on 20th October 2021, you have claimed an amount of rupees 92 lakhs 23,309. Copy of letter is annexed at annexure C. Now, kindly takes part 4 of that also, which is the second section 34 application. In your letter dated 9th June 2021, you have claimed an amount of rupees 67 lakhs 8,281 against contract number 138524, which is the second contract. As on 20th October 21, the figure has changed to 34 lakhs 80,485. Now, thereafter, kindly takes the last paragraph. I'm sorry, the paragraph after 4. We have reconciled the account with your vice president with a copy to the president, the CEO in mail dated 20th October 2020. Copy of the email of Shrey dated 20th August 2020 is attached as annexure F, from which it reveals that your letter dated 20th September 2020 is full of anomalies and as an attempt has been made to put our company in a distressing situation. Now, there were enclosures with this letter. One by one, may I disclose?
So this alleged date of reconciliation is prior to the award?
Yes.
Award is 17th of September?
Yes. Alleged date of reconciliation is prior to the award, yes.
Now, but do they admit? You say that they admit subsequently their.
Yes. In 2022, they finally admit by their letter. I'll indicate that. In 2022, if your lordship takes page 120. So, my lord, in 2022, by their letter of 7th of October 2022, which I just read before your lordship, my lord, they enclose this and they say that this is, according to you, this is still the amount which is due and payable. Now, my lord, kindly sees page 120. Lordship will find, my lord, the contract number in the first table in the third column. My lord, the fourth contract is the, my lord, contract, which is, my lord, the subject matter of 529, AP number 529. My lord, the status your lordship will find is live. Status is, my lord, live, and thereafter, my lord, your lordship will find the dues which have been, my lord, arrayed against, my lord, the contract numbers, the overdraft amount, future dues, ODC, such and such amount, and the, my lord, total dues.
Where do I find the date of this email, Mr.?
Yes, my lord, the date of this email.
Can't find any date here.
I'll tell you, lordship, my lord, the date of this email is, my lord, 20th August 2020, which is, my lord, referred to, my lord, in the letter of 7th of October 2022, where they acknowledge, my lord, this is, my lord, according to you on 7th of, so, my lord, their letter of 7th of October 2022 really says that the last reconciled amount, according to you, on 20th
This
August
was prior
2020.
to this was prior to the award.
Yes, but 7th October 2020, 2022, they
Yes.
say they do not speak anything about the award. They do not say that this has been settled or a nil award has been passed against you. There is no whisper in their letter of 7th October 2022 that this is not payable by us because of the dint of the award, passing of the
Not
award.
that they subsequently admit to the claim.
My lord, yes, if
Or-
your
or to
lordship
the
kindly
dues.
takes, my lord, if your lordship kindly
They don't
now
refer
takes,
to the award. That you may say.
but if your lordship, my lord, kindly takes 7th October 2022.
Where is that?
My lord, this is, my lord, if your lordship, my lord, the letter we were referring to, my lord, is at, my lord, page 107. This is an annexure, my lord, the
Is
series
that-
of annexures is, my lord, the,
Here they don't admit anything.
yes, my lord, if your lordship kindly sees,
They refer to your claims and they say we have reconciled the account on 20th of August, which is corroborated by this email of 20th of August.
they say, my lord, if your lordship is at page 108, 108, the second Roman 2, in your letter dated 9th June 2021, 9th June 2021, that is post-award, you have claimed an amount of rupees 1 crore 51 lakhs towards contract number such and such. But on 20th October 2021, you have claimed an amount of 92,000, 92 lakhs 23,000.
That speaks about your claims
That
being
speaks about my,
altered.
yes, that
time
speaks
to time.
about my claims. Copy of the letter is rexed.
Roman
Now,
1 to 4, all are your claims. They speak about your claims, but they say in the next paragraph that you have already reconciled on 20th of August 2020. And there's that email.
yes, my lord. If your lordship now kindly takes part the reconciliation statement, but the statement that they made, we have reconciled the account with your vice president with a copy to the president. The CEO in email dated 20th August 2020. So, my lord, what it really does is that, my lord, they say your claim was X on a Y date, and now you're saying your claim is Z. But you have reconciled the amount prior to, my lord, passing of the award. You have reconciled the amount.
So the amount has now become X, EX.
So they are saying instead of X, it has become Z. Instead of X, it has become Z.
But they don't
But
say
they
so.
do not say that it has become nil because the award has been passed.
Not exactly. Here, suppose let us
Now,
take take
yes.
this Roman 2 or 4, whatever.
Yes.
They refer to one letter of yours dated of 2021.
You have,
They say that amount of your claim has changed in a subsequent letter.
yes.
But then they go on to say in the next paragraph that we have reconciled the account with your vice president with a copy to president in mail dated such and such, which is prior to all these claims of yours. So we have already reconciled. That is their statement here.
Yes,
don't
and the
admit
reconciliation statement says that an amount is still due and payable. So in effect, the
Why do
reconciliation,
they say that?
they have annexed annexure F, the reconciliation statement.
Yes.
Reconciliation statement, they say the amount is due and payable.
That is page 120.
That is page 120. So if they are reiterating on that page 120 now in 2022 by saying that these amounts according to me is due and payable, these are the reconciled amounts, not 100 rupees but 50 rupees is payable. That means they are admitting that dues are still payable. Where is the question of passing of a nil award in between?
Please come to page 120. Where,
Yes,
what are the dues?
Sir, आपने की So page, your lordship
120.
kindly takes note page 120.
Yes.
Your lordship will find in the first table 130.
Also those lives.
Yes, live and the amount which has been arrayed against the contract numbers, which are still showing as due and payable. Interestingly, the table thereafter, Manoj, kindly sees Manoj, the table thereafter. Client had offered 40 lakhs in such and such, kindly leaves that.
Yes.
It says the net liability, including all these contracts, is 81303391. The net liability admits. So this reconciling.
What is that net liability? Sorry.
I'm sorry, Manoj. This is Manoj towards Manoj after Manoj the disagreement with the client heading towards the bottom of Manoj page 120.
Yes.
Your lordship will find asset securities. Your lordship can find asset
security. Yes.
Just before that, net liability.
Oh, yes. All right.
Live 1305853 live 1305853 এই দুটো অ্যামাউন্ট দেখিয়েছে তারপরে বলছে এটা লাইভ কন্ট্যাক্ট স্যার আপনি নিন না না তো বল স্যার আপনি তাহলে
Your lordship will find, I'm really grateful to my learned senior Mulad. Lordship will find Mulad that in the first table, live, as your lordship had pointed out, Mulad, live against Mulad the contract number 130583 and live against the contract number 138524, which are Mulad the subject matter of Mulad the two section 34 applications, and Mulad the amount which has been Mulad arrayed against Mulad those Mulad contracts in the table, where it shows that the amounts are still due and payable. And not only that, Mulad, your lordship will also find that just after the two tables, lordship will find liability as per Shrey is such and such, repo sold asset such and such. So total liability is around 115 crores or something like that, which they are saying they are in disagreement with the client.
Yes.
And
the
they're
disagreement
admitting
amount is 773 and the net liability remains. All right.
So, Mulad, in 2022, they are harping on this letter where they are saying that no, it's no nil award.
So,
and there is no mention of it.
120 read with 107.
Yes.
First of all, reiterates this this liability of 813 such and such. Yes. Not only that, they also don't refer to that arbitral proceeding or award at all.
At all.
All right.
At all.
Proceeding at all.
Yes. Because Mulad, 7th October 2022, we are Mulad really 2 years after the passing of the arbitral award.
Yes.
So if the parties, in fact, Mulad, I'll not trouble your lordship, Mulad, all the series of correspondence which they have annexed in Mulad 7th October 2022 letter, which is part of Mulad the annexure in the supplementary affidavit, will go on to show that we have time and again demanded those amounts. And to that, their reply is 7th October 2022 saying that your amount is, admitted amount is not X but Y, but Y is still admitted. And
there are other correspondences also.
Yes, Manoj, your lordship will find it from Manoj after Manoj the letter of Manoj 7th of October 2022. Your lordship will find it from page 109 onwards. Nothing at all. No whisper about any award in any of the correspondence.
And interestingly, my lord, when they were confronted with this, my lord, petition under section 34, and if I may use the word, my lord, we were also, my lord, audacious enough to, my lord, come up with an application of section 36 for stay of award on the ground of fraud. They did not, my lord, come out with any documents to show.
Well, the first question I asked, I mean,
No
whether there is a-
documents to show, my lord, that the award had happened, minutes, or if the parties had been given back the minutes or the claims or the papers according to the learned arbitrator, then they ought to have their set of, my lord, documents.
Yes, yes.
Now, if your lordship, my lord, takes, my lord, the grounds that, my lord, were raised. ওই grounds গুলো এক এক করে ঠিক আছে। Your lordship, my lord, now, my lord, kindly takes, my lord, the grounds on the basis of which, my lord, we have, my lord, asked for, my lord, setting aside of the award.
Just give me half a minute.
Yes.
Yes.
Your lordship, my lord, kindly takes, my lord, very briefly, my lord, may I just
You are reading the grounds of the section 34.
Yes, my lord, I am
You
just
can read the
indicate.
ground,
I'll just indicate, my lord. I'll just indicate, my lord. I have, my lord, ground, my lord, 5, ground 6, 7, 9, 11, 12. We have, my lord, taken the ground of, my lord, unilateral appointment opposed to, my lord, public policy.
Please repeat once, 5, 6.
My lord, I'm sorry, my lord. Ground 5, 6, 7, 9, 11, and 12.
12.
Yes. We have taken, my lord, that they have, my lord, not, my lord, unilateral appointment. We did not know. The award was never given to us. Now, my lord, coming back to, my lord, their, my lord, defense to the section 34 application. Water, please. Coming back, my lord, to the defense to the section, my lord, 34 application. The first, my lord, defense that they take is, my lord, that the award was never served on, my lord, the petitioner, and hence the section 34 application is could not have been filed.
Premature.
But no point of limitation did not commence under section 34(3). So that was, my lord, one of the grounds which were taken.
No, I don't understand.
My lord, yes, my lord, that no
Because
cause
it
of
has not
action
been
to file, no cause of action to file section 34 because the award itself was never served on, my lord, by the arbitrator to, my lord, the
very
well. I'll
What
just, my
next?
lord, I'll perhaps, my lord, I have, my lord, relied on a judgment also, my lord, on that. I'll just indicate, my lord, and, my lord, repeat the, my lord, citation, my lord.
No, the limitation that is for the purpose of counting limitation period.
Yes, yes.
When
They had
the
taken
award
the
is
point.
served.
They had
But
taken that point.
not that you cannot challenge the award before that.
No, they said that we were very well aware, and thereafter we did not. I shall, my lord, go through, my lord, the reply, the opposition that they have filed.
Now, what about the fraud? I mean, this happened and all. They don't substantiate by producing any document whatsoever regarding the arbitration.
Nothing.
Section
Not
21.
not one document.
From section 21 till before award. Nothing.
Nothing.
Something, my lord, I have never come across. This is in my experience, my lord. Almost I'm going to complete 60 years. I have not seen anything like this. This is, and I cannot ascribe any motive to the learned arbitrator. After all, he was a judge. She was a judge. But then, my lord, it was puzzling. When I received the brief, my lord, I could not believe that this is possible. No paper, nothing. And my lord, the award that's been recorded, this is what is very, very surprising. I have carefully considered and gone through the pleadings, submission, arguments of the claimant, documents on record on behalf of the claimant, and the case law cited.
Mr. Mitra, in their opposition, have they taken any point that because this was passed some time back, we have lost, and they have not levied execution also? Execution has not been levied.
Nothing at all. First time we get to know of this.
Probably they also come to know for the first time after you say. When they disclose it in their affidavit in opposition. Otherwise, I mean, they did not even levy execution. So
No.
why take the risk? Yes. So yes, what else?
Malad, judgments, Malad, were cited, Malad, on the ground of Malad fraud on the last occasion.
What were the judgments cited? Judgment দিয়েছিল কিছু? You cited Dakshin Haryana Bijli 2021 7 SCC.
Yes, that is on limitation.
They probably cited, they went back to Privy Council. At least on my record, 54 LW. Law Weekly also.
Not given cover notice.
It comes directly under section 35.
Yes, Mr. Mitra, you can take over.
Well, I was just thinking section 34, subsection 2.
Yes.
See, it
Arbitration
comes
Act.
directly under that. Apart from question of fraud and things like that.
Yes.
Section 34.2, an arbitral award may be set aside by the court only if 3, III. If the party making the application was not given proper notice of the appointment
Yes,
of an
yes,
arbitrator
yes.
or of the arbitral proceeding, or was otherwise unable to present his case. I comes directly under that because I had no notice, no knowledge of all this. And then, my lord,
If it's fraud, then also comes under public policy.
yes, of course.
And fraud is itself, explanation 1 is.
Yes.
And 2A also probably.
Capital 2A.
Patent illegality, I mean, they need not go to that extent.
Finds it that it is.
Need not go to that extent even.
My lord, the difference between subsection 2 and subsection 2A, basic difference is this, that the subsection 2 imposes an obligation upon the party to bring it to the notice of the court. It says arbitral award may be set aside only if the party making the application establishes on the basis of this, on the basis of the record of the arbitrator. I'm first of all establishing that on the basis of the record of the arbitral tribunal. First 2A III. Apart from it, my lord, 2 capital A, it is the court's duty. If
Yes.
an arbitral award arising out of arbitration or other international commercial arbitration may also be set aside by the court if the court finds. It's a finding of the court. Really, my lord, if I may, I can't say the onus upon the court, but
No, but yes.
Court has got a duty not to, my lord, enforce an award if it finds that the award is vitiated by patent illegality appearing on the face of the. I'm saying it's appearing on the face of the award because this entire enumeration of facts in the award is, my lord, non-existent.
So 34 A3 III, B II, as well as 2 capital A. BII means public policy, which takes within its fold fraud,
Yes.
as per the explanation.
And my lord, kindly note another thing. This is
Yes.
something which I had the occasion to ponder about. This, my lord, kindly comes to section 36. 36(3) proviso. Surprisingly, this particular language is not there in section 34. Section 36, subsection 3, proviso.
Proviso. Sorry, 36(3).
This is with regard to, my lord, staying of the arbitrator, the operation of the award. There, provided further that where the court is satisfied that a prima facie case is made out that the arbitration contract is the basis of award or the making of the award was induced or affected by fraud or corruption. it shall stay there what unconditionally. But surprisingly, my lord, similar provision should have been there in section 34.
But 34 B II takes care of that.
It does take care of it.
II says in conflict with public policy, and then explanation has been hurriedly added, not hurriedly, in fact added later. So for the avoidance of any doubt, clarified that public policy includes one is fraud. So it does in a sense. But where is the scope of stay of a nil award? I mean,
There is no scope of stay.
stay in the
Setting aside of the award is the only thing that I can think
setting
of.
as a yes.
In the facts of this particular case. Well, this is something I have never come across. And I was puzzled. In fact, I was not agreeable to accept the fact because this was an allegation against the arbitrator who was a retired district judge.
No, even then.
But then again, my lord, when I
That is all the more a reason you should take up the my lord to purge this whatever. So your arguments are concluded for the time being. So
Right.
we'll
Well,
close.
I shall just check up if there is anything else. My learned junior has very exhaustively placed.
Yes, you also placed on the last occasion. So I have my notes on that, and he also placed it very exhaustive. Very well. So we'll keep it as part of heard learned senior counsel appearing for the petitioner at length, full stop. For further hearing, the matter is adjourned till February 14, 2025.
आज तो मुश्किल है नहीं तो आज तो मुश्किल है हम देखते हैं संडे का दिन
ये माइक ऑफ करके रख।
Yes.
Yes. Lord, may I be permitted to mention one matter? This is a contempt application.
My order. My order.
Yes.
Yes.
My Lord, 22nd February
Hand over,
2000.
hand over. Yes.
Great.
As well as kindly to mention item number 53 of my lord's list. This I had mentioned on the last 2 weeks. Your lordship said that this would appear as top. It is appearing as top of that heading, my lord. There's extreme urgency, my lord. Kindly pardon me for mentioning it over and over again. My lord, your lordship has quashed the entire servicing proceeding. Despite that, a notice for sale of my property has been given. My lord, because it's a section 95-96 of the Insolvency and Bankruptcy Code, your lordship has quashed everything. Despite that, a notice has been given, and now I run the risk of my property being, and it would create third-party interest unnecessarily. Possibly, my lord.
Well, this will appear at the top next Friday. This at the top মানে একদম top থাকবে।
I'm
At the
sure.
top.
If it is not taken up today, otherwise. Great.
Lord, may I be permitted to mention, my lord, item 73 and 74 of today's list, my lord. This is a first miscellaneous appeal of 91. My lord, it was dismissed for default in 2014, my lord. Some preference, my lord. If it can be taken up at 3:30, my lord.
Not today.
My lord,
Applications are very well.
my lord.
পরের শুক্রবার অ্যাপ্লিকেশন গুলো মোশনের আগে দিয়ে দেবেন।
Grateful.
Next Friday, reform motions.
The part-hard matter, the Metsil matter, the electricity, it was hard matter completed. I have to reply the
No, Mr. Chakot, these motions have been assigned to us to get them over with. I mean, 100 have been assigned, 50 has been done away with, and 50 are left. So let us give me some time. I'll take up all of them. All on the list. আগে এটা দেখুন আর কি কোড ব্লেডটাকে দেখে না মুখে বলে দেবেন অ্যানাউন্স করে yes yes
my lord, we have complied with the order, my lord, past the your lordship's direction was to give the documents and pass order, my lord. The deputy commissioner has done that, my lord. Affidavit of
Yes,
compliance has been filed, my lord.
Mr. Kumar, they have complied?
Yes, they have complied. They have complied.
We'll drop the contempt then?
My lord, my lord, my lord.
Very good. Thank you. Learned counsel for both sides points out that the order of this court has been complied with in the meantime. Full stop. As such, comma, the contempt proceeding need not be kept pending further. Accordingly, CPA in 47 of 2024 is disposed of as infructuous. Thank you.
I'm grateful, my lord.
Most good.
Thank you. As you list. Appear, give the appearance. Correction. Not today.
Item number 2, repeat matter.
Yes, rule was issued. What is?
No,
They're appearing online. What was the content, Mr. Datta?
My lord, kindly first takes lordship's last order. Lordship had, my lord, kept it, my lord, today. With, of course, my lord, direction on the alleged contemner to be present online. There was a pending appeal, and I was being led by Mr. Abrutosh Mojumdar. He had, my lord, fairly indicated that it was to be listed. Now, my lord, that appeal bench has been, my lord, constituted to hear that appeal from the review. Now, that was listed, my lord, day before yesterday, and it's now due to yesterday, and it's now due to be listed again next week, my lord. So, my lord, in all fairness, my lord, I should, my lord.
March 7th.
Very good.
Learned counsel for the petitioner, in his usual fairness, points out, in agreement with the learned advocate general who is appearing for the alleged contemner, that the appeal preferred against the order seeking review of the parent order is due to be heard anytime soon. Full stop. Accordingly, comma, for the sake of propriety, let the contempt application stand adjourned till March 7, 2025.
My lord, may the last, my lord, direction remain, my lord, that
the alleged contemner for the time being, the personal appearance of the alleged contemner, comma, either personally or virtually, is dispensed with for the present.
But may be noted that she's present today.
প্রথম লাইনে একটা অ্যাড করে দিন the alleged contemner is virtually present today when the matter is called on for hearing.
I'm grateful.
Grateful, my lord.
2 থেকে 4 হয়ে গেল,
মানে 2 to 4 together.
2 to 4, yes. ওগুলো অন্য করে তো।
Item number 5.
You are for the petitioner. Rule was issued.
On behalf of the respondent, your lordship.
Yes. Same side or?
My lord, there was a direction, my lord.
Yes.
On the alleged contemner to file one reply to the rejoinder. My lord, may I pray for a judicial grace of 1 week, my lord, because
They have.
If they show grace, then we'll.
I shall not stand in an advocate's praying for.
On the prayer of the alleged contemner, the time for filing reply is extended till February 14, 2025, when the matter shall next be listed for hearing.
Great.
An advance copy of the reply shall be served beforehand on the learned advocate for the petition.
Item number 6.
What is the matter? Mr. Shamul for the other side. Right. Yes. What is the matter?
To file the supplementary.
Yes. You have given a copy, we hope.
Yes, my.
Very good. Din. Are supplementary affidavit din. কি করছেন আপনি পুরনো লোক?
Being aggrieved with the order passed by learned third small causes court Calcutta, my lord, against one recalling application filed at my instance, my lord, under section 151 of CPC.
You sought a recall of what order?
Recall of rejection, dismissal of my application of under order 21 rule 101 CPC, my lord. My lord, the crux of the matter is, my lord, my grandfather was originally tenant under the suit property. He died in 1958. After that, my lord, his two sons, my father and my uncle HON'BLE Banerjee, who was subsequently who became the tenant of the suit property, we used to reside in a joint mess, the property, my lord.
Your father and your uncle, or you and your uncle?
Father and uncle. Subsequently, father died, and we continued.
You, Kevin.
We continued. My lord, one eviction suit was filed by the opposite parties against my uncle. Suit was at the time of after filing of the suit, my lord, we filed order 1 rule 10 application for addition of parties that was allowed by the learned trial court below, but the landlords filed an application, revisional application, and Honorable Justice Shaw mentioned rejected that order, my lord.
Allowed the revision, set aside that order.
Set aside the
On what ground was it? Was the revision allowed?
Revision was allowed that we could not take the plea of section 2H of the old act, my lord. That was the I'm showing your lordship the order says civil revision order.
That means that period has the statutory period has elapsed and you are no longer a tenant. That's why. That was the premise of the. Then what happened? Then decree.
Then it was ex parte decreed, my lord.
And you took a same point in your order 21 rule 101. So
I took the same point.
Rightly
order 21. One thing, my lord. My lord, kindly consider order 21 rule 101. I filed. The landlords filed on non-maintainability application section 1 under section 151 on 5th of February 2020.
Yes.
Order 21, it was rejected. After that, the proceeding was pending for several months. I have filed.
Proceeding means the execution case.
No, my order 21 rule 101 proceeding, my lord.
The maintainability application was rejected.
Maintainability application was allowed, which was filed at their instance.
How could it be kept pending?
I have filed the case status, my lord. It was pending.
That was an error.
My lord, after
if the maintainability was allowed and your application under order 22-101 was held to be not maintainable, it stands rejected.
But one humble.
You have sought for a recall of which order?
Sir, recall of that order 20.
Maintainability allowing.
Yes, 5th February 2020. My only humble submission, my lord, kindly consider the order of Honorable Justice Shaw mentioned, which.
Yes. Which page?
It's page 8.
Yes. 8. No, page 16.
It's 16 now. Oh, my
yes.
16 of my application.
Right.
But it's a change it, so the pages.
No difficulty.
My lord, kindly consider page 17, last paragraph. The observations made in this order are only for the purpose of determination of the issues raised in the application for addition of parties. This order shall not influence the trial of the declaratory suit filed by the opposite parties.
Would not affect the suit, but you cannot take the same point in a order.
Relying on this order, my lord, my order 21 application, rule 101 application was rejected in limine, and that is mentioned. Order 21 rule 101. If I'm not correct, I'm not wrong, my lord, should be considered after framing of issues and after trial, my lord. It was rejected in limine, just only on the basis.
Palpably barred by the principle of res judicata. You know the fate of your revision before you came to the court.
I bow down.
You have tried your level best. I'm dismissing. Sorry.
I'm leaving up to you.
Heard learned counsel for the parties. Full stop. The present revisional application has been preferred against an order whereby the petitioner's application for recall of a previous order holding the petitioner's application under order 21 rule 101 of the Code of Civil Procedure to be not maintainable, has been turned down. Full stop. Next para. Learned counsel appearing for the petitioner submits that the petitioner claims to be a joint tenant in respect of the decretal property. Full stop. The petitioner applied under order 1 rule 10 of the Code of Civil Procedure for being impleaded as a defendant in the eviction suit filed against the other joint tenant, that is the uncle of the petitioner. Full stop. The said application was that application was allowed and was initially allowed by the trial court. Full stop. An application under Article 227 of the Constitution, however, was preferred against the same by the plaintiffs / opposite parties, which met with success. Full stop. Next para. Subsequently, the suit was decreed against the uncle of the petitioner, and the petitioner took a plea of joint tenancy in his application under Order 21 Rule 101 of the Code before the executing court. Full stop. Learned counsel argues that although the petitioner's prayer for impleadment was turned down by the revisional court on the earlier occasion, on the premise of Section 2 (h) of the West Bengal Premises Tenancy Act 1997, there was a specific observation in the order of the revisional court dated June 6, 2016, that the observations made in the said order were only for the purpose of determination of the issues raised in the application for addition of parties, and the order shall not influence the trial of the declaratory suit filed by the opposite parties. Full stop, next para. As such, it is submitted that the order holding the Order 21 Rule 101 application not maintainable failed to consider such aspect of the matter. Full stop, next para. Learned counsel for the plaintiff's decree holders opposite parties opposes the same and points out that the Order 21 Rule 101 application was filed on the self-same ground as the Order 1 Rule 10, and as such was rightly held to be not maintainable. Full stop. Upon a careful perusal of the order dated June 6, 2016, passed by the Revisional Court in CO 922 of 2016, I find that the observations made therein were categorically held to be for the purpose of determination of the issues raised in the application for addition of parties, although the same would not influence the trial of the declaratory suit. Full stop, next para. What the present petitioner has sought to achieve now is to indirectly achieve what he could not by way of the Order 1 Rule 10 application. Full stop. Even going by the observations of the Revisional Court, the observations made therein applying the provision of Section 2 within bracket small h of the 1997 Act to the petitioner, where for the purpose of determination of the issue raised in the application for addition of parties, which is exactly identical with the issues raised afresh under Order 21 Rule 101 of the Code of Civil Procedure. Full stop. Hence, although the revisional courts might not have been binding at further stages of the suit itself, such observations clearly operate on the principle of res judicata insofar as the self-same defense taken by the petitioner in the petitioner's application under Order 21 Rule 101 of the Code of Civil Procedure. Full stop. Hence, I do not find any illegality or jurisdictional error in the learned executing court refusing to recall the order holding the application of the petitioner under Order 21 Rule 101 to be not maintainable. Full stop. Accordingly, the revisional application fails. CO 461 of 2024 is dismissed on contest without any orders to cause. প্রথম লাইনে দিয়ে দেবেন একটা supplementary affidavit filed to be kept on record. Sorry, you argued well, but next. Thank you. Next. Give the appearances, please, in the previous one.
For the opposite party.
None appears second occasion, I'm dismissed.
Only one thing, perhaps it has become infractuous also.
Oh,
Why,
yes.
Under in the aid of miscellaneous case number 30, which arises out of an application under Order 21 Rule 99 to 101, this stay application is being refused, which is order impugned before your lordship. Subsequently, the Order 21 Rule 99 application itself, the miss case, has been dismissed on merit.
I'll record that and
only one indulgence, may I say? Yes. Here, the Supreme Court has affirmed the order of eviction. They have insisted the Supreme Court that yes, they will file an undertaking. On the basis of that, the SLP was being dismissed. Thereafter, within the time span, they have not even filed any undertaking, which prompted the registry of the Honorable Supreme Court to communicate the registrar of this Honorable Court that they have not filed any undertaking pursuant to the leave granted by the Honorable Supreme Court. Thereafter, they took out all these applications, which prompted, my execution case to be stalled. Kindly see, the coordinate bench of order of your lordship's court, even on this revisional application, at the time of first hearing. Kindly expedite, I am suffering, for last 15 years.
None appears for the petitioner at the time of call. Learned counsel for the opposite party submits that the present revision has become infructuous since the same has been preferred against an order refusing grant of stay at the behest of an applicant in an application under Order 21 Rules 99 to 101 of the Code of Civil Procedure. Full stop. It is submitted that the parent application under Order 21 Rules 99 to 101 has itself been dismissed subsequently, and as such, there is no scope of grant of stay, which renders the present revision infructuous. For some next para, it is further submitted by learned counsel for the opposite parties that the judgment debtor stroke petitioner, no, sorry, that the execution case is being stalled indefinitely. Push up initially, the matter went up to the Supreme Court, where an undertaking was given by the judgment debtor to leave the suit premises subject to filing an undertaking, which was never filed. Full sub next para, accordingly, an expeditious hearing of the executing court is prayed for. Full sub next para, on the in the light of the discussions above, comma, CO 2357 of 2024 is dismissed as infructuous without any orders to cost. Full stop. The executing court is requested to expedite the hearing of the execution case as far as possible and positively to conclude the same within 3 months from the date of communication of this order to the executing court.
Extremely good.
Right.
Item number 8. My lord, I am for the petitioner.
Yes, Mr. Mukherjee.
In an order 21, rule 97, 101 proceedings.
Lordship, item number 8, I'm praying for a not today.
Refused. You are the judgment debtor.
Lordship, I'm the decree holder.
Then we'll grant. What is the challenge against?
My lord, I am in that proceedings. There was direction to pay occupational charges. 75 rupees has been enhanced to 5,000 rupees.
What is the area? Location?
One room, 130 square.
What is the location, area?
Location, I have annexed the photographs. It's
Lordship, location is
Hastings.
Hastings, yes.
No,
Very posh area.
No, it is a Canal South Road, not necessarily Hastings. By police station Hastings does not mean that that is a very coveted area.
It comes in that jurisdiction itself.
Lordship may kindly see the page 163, where I have annexed locality photographs of the localities. 164 and
But we can grant you adjournment. The difficulties, if you, I mean, their stay would become
Lordship,
negative.
Lordship, kindly give me a note today because the conducting advocate has gone for comb.
Gone for HON'BLE?
Yes.
No, refused. So what, Kumbo?
Lordship, I don't even have the brief with
Kumbo
me.
just, I mean,
Lordship,
is not a
I
jurisdiction.
don't even have the brief with me, Lordship.
10th March data, sir.
But you cannot take advantage of your own adjournment by, I mean, their stay will go then. It's a conditional stay they have been granted. And they've challenged the occupation charges. Then we'll grant a stay of the operation of the order if I'm satisfied. Let me hear them prima facie for the purpose of stay. Yes.
my lord, kindly.
You have to deposit that amount. That time is over.
Yes, but I have filed before that. Let there be a limited period of stay.
Page 163. That photograph.
Photograph is at page 163, and Lordship kindly sees page 169 also. 169 is the rate of rent of the upper floor.
Revisional code cannot go into facts, but this is that hut.
This is no, the adjacent building, the locality.
Right hand side.
Right hand. No, the
Yellow or blue?
This. Which one? This is the one. This is.
If it's blue, if the blue one is the, then it comes under Article 12. You have painted it blue and you're seeking undue advantage of that.
And it is a.
The blue one is a good building. I mean, why shouldn't you pay 5,000 for that?
No, why I'm saying it's a one room, common kitchen, common privy with other tenants.
These are competing photographs.
Lordship, this is actually the building where the tenant is residing right now.
Oh.
And these are the rooms. This is the only one room I am using.
Let us see the impugn order.
Lordship also says 169, the rate of rent of the tenant staying at the first floor, 800 rupees.
That is not an indicator. The current market value is the indicator. That might have been granted long back.
My lord, it is at the on 30th June 2024.
Yes, if you are inducted long back, that rent is continuing.
And
that is not an indicator.
Then comes to the impugned order.
Let us come to the impugned order.
Discussions why it should.
That is what I want to see.
That kindly comes to the page 3, second paragraph. Considering the petition from where the
This is in connection with that your order 21-101. What is your claim?
My claim is, my lord, the
Independent tenancy.
independent tenancy, I am not bound by the decree.
The decree was passed against the person holding that he's a what? Trespasser or
No, decree has been passed not against me.
illegal subtenant.
Illegal subletting, whereas
You are that illegal subtenant.
yes, that has been held by the learned trial court. But my lord, what has happened? The tenant against the person against whom the eviction suit has been filed had surrendered the tenancy by a letter. After that, I have been inducted. Rents have been taken from me. Then they stopped taking the rent. I am still depositing before the rent controller. Suit has been filed against the erstwhile tenant without impleading me as a party. I sought to be impleaded by
Pay 3,000. I'll take it up next week.
Lordship, 3,000 is a very meager amount. 5,000 also for 120 square feet Hastings area. Kindly consider even that is.
You're ready in the matter. Let us
Lordship, I don't have the brief, but that is a very even
There
5
is
from
no
5
basis whatsoever in the order. Not a single line attributed to what is the reason for this.
Kindly grant me
Because
not-
what we do is in this court also, we take affidavits and we decide on affidavits. Yes, something contemporary has to be furnished by you to show the market
That is
trend.
why I'm praying for a not today.
So I can set it aside and send it back to the court below for re-adjudication on this. Permit both of you to furnish documents to show what is the current market value.
Lordship, I understand. I think that has been done. Lordship, let the conducting advocate come back next week. He'll do the matter.
Take my copy and see where it is. Mr. Mukherjee, give your copy. The impugned order. The impugned order. Give the impugned order. Don't hand over the entire thing.
No, that's a.
No, the impugned order. Find out the impugned order.
Sorry.
Lordship, kindly keep it a passover for 10 minutes.
Yes, I'll do that.
Great.
I'll do that. Pass over for 10 minutes. Whenever you are ready, just mention the matter. I'll take it between matter. Yes.
Item number 9.
Yes.
9, my lord, I beg to appear on behalf of the petitioner, my lord.
Chatterjee, you are appearing 9?
My lord.
Yes, for the petitioner.
My lord.
Right,
It's only a prayer for expeditious hearing, my lord, of a probate proceeding or letters of administration proceeding, my lord. There were orders from this honorable court. Even, my lord, your lordship will find at page 15. There was an order from this honorable court. Even then, my lord, every day time is being granted. Every day. My lord, I would not have troubled your lordship. It's at 15, my lord.
Is there any pending application, Mr. Chatterjee?
There is nothing. Evidence is on, my lord.
In view of the innocuous nature of the prayer made in the application, comma, prior service of notice is not being directed. The petitioner alleges that the petitioner's application for grant of letters of administration in respect of a will has been protracted indefinitely. I find from the materials annexed to the application that inordinate delay has been occasioned in disposing of the matter. The proceeding was initiated as long back as in the year 2019 and is now pending at the peremptory hearing stage. However, several adjournments have been given. Next para. Accordingly, CO 2887 of 2024 is disposed of by requesting the learned
My lord,
Judge, 5th Bench, City Civil Court at Calcutta, to dispose of OC number 3 of 2022 as expeditiously as possible without OC number 3 of 2022 arising out of what is OC number 3?
OC number 3 is the letters of administration matter.
Then what is LA case?
LA is a different thing, my lord.
Letter
There
of
were
admission,
3
LA is-
proceedings. Yes. I'm sorry, my lord. Just give me 1 second, I'll tell you.
Yes, OC is something, some interlocutory thing.
Yeah, OC is a different thing, my lord, altogether.
Then?
Millard, if I could directly assist, Millard, LA was the application for grant of letters of administration. The opposite party number 1 herein filed their opposition to that. That was converted to a contentious case and it became OC number 12.
Alright, so this is the same matter. Same matter.
So it is the same case.
Who are being heard together?
No, my lord,
The
the
same
same LA case was converted to OC because they filed an opposition to.
Acha. কোনখানটা ছাড়লাম? OC3 of 2022 pending in the said court as expeditiously as possible without granting unnecessary adjournment to either side, comma, positively within 6 months from the date of communication of this order to the learned trial judge. No rest to cost.
Great for the
Thank you.
10, I beg to differ for the petitioner. This is an application for expeditious hearing of a misappeal, my lord, 46 of 2023, pending before the my lord learned
2023 appeal we
district. Misappeal 2023.
Even then.
My lord, suit is my lord 2020,
No.
2014, my lord.
2023 is too early. Courts are heavy
My lord,
pressed.
kindly consider, my lord, suit is for 2024.
No.
My lord, the injunction order was passed, my lord,
Maybe.
on my lord 2nd February 2023. Thereafter, my lord, only for my lord SR.
No, we won't grant any timeline. I won't grant any timeline.
My lord, but kindly, my lord,
Well, as expeditiously as possible for the court. We'll do that only.
only my lord is for my lord SR, only for SR.
Even
Every
then.
date for SR and
Even then.
last date, my lord, only the LCR has been called for.
So what is the fault of the court?
My lord,
SR, if the service return
am-
is not complete, then the court
I am
cannot
the
take
my
up.
lord
Court is not
contesting
at a fault.
defendant. They are the my lord plaintiff.
Whatever you are, if it's pending for service return, the court is not at fault. What can the court do?
Since my lord March 2023,
No,
my lord,
maybe.
this is fixed for my lord.
The grievance of the petitioner is that the miscellaneous appeal preferred by the petitioner has been
My lord,
kept
not
pending.
not me, my lord. By the plaintiff.
That a miscellaneous appeal preferred by the opposite parties has been kept pending since March 2023. Full of next para. After perusal of the materials, comma, I find that the majority of the adjournments granted were due to service having not yet returned, and as such, the learned district judge Paschim Mednipur cannot be blamed as such. Full however, comma, keeping in view the urgency of the petitioner, comma, CO 3026 of 2024 is disposed of with the expectation that the miscellaneous appeal shall be disposed of by the learned district judge, comma, Paschim Medinipur as expeditiously as the business of the said court permits. Full stop. In view of the innocuous nature of the above order, comma, no service of notice is directed on the opposite parties. No rest to cost.
Lordship, I have a kind indulgence to.
You are ready?
Yes.
Let this be moved after this. Inform Mr. Mukherjee that yes. So I'll take up this matter since it has been called. Yes.
I beg to be excused, my lord, on the last occasion, my lord, I have embarrassed you, lordship, my lord. Actually, I was not prepared. I'm sorry, my lord. Extremely sorry for that, my lord.
For what? I don't understand.
I was not prepared, my lord, but I have embarrassed you, lordship, my lord.
You made contradictory submissions.
I could not give answer.
Now you are prepared.
Yes.
Move it.
I'm sorry, my lord. Extremely sorry.
Accepted. Yes.
Fine. Expeditious disposal.
Expeditious disposal.
Yes, my lord. In the year 2006, my lord, the plaintiffs, my lord, filed application.
What is the stage of the suit? What is the stage of the suit?
For argument. And
Argument.
one after another.
No application is pending.
Eh?
No application is pending.
For argument.
No application is pending. Even during argument, sometimes applications are filed.
One application, maintainability application.
Maintainability of suit.
No. One application has been filed by the defendant number 1. That defendant number 2 has not filed the application under Order 7, Rule 11. Because actually, he is
No,
not
I am
paid
asking you what applications are pending in this
Yes,
suit.
no. I'm showing, my lord. I'm showing.
Tell me, don't have to show anything. What are the applications pending?
My lord, what has happened? First, Order 7, Rule 11, they filed. Order defense struck off previously. And Order 7, Rule 11 filed by.
Who is the gentleman sitting there?
Number 1.
Sir, who is the gentleman sitting there? This is meant for advocates, please. You have your conference outside the courtroom. Yes, please continue.
Order 7, Rule 11 filed by the defendant number 1. That was rejected. When rejected, suit, my lord, was decreed ex parte earlier. Then Order 9, Rule 13 filed by the defendants. That was allowed. Suit continued. Evidence continued. My lord, after evidence, conclusion of evidence, they are filing one after another frivolous application like, my lord, Bolashaw has filed an application that no, under section 24, my lord, for transfer of the case. That application has been dismissed. Shankar Shah has come to file by filing an application under Order 7 Rule 11 that no, under Order 9 Rule 13, the ex parte decree was allowed, and thereafter I did not contest. And Order 7 Rule 11 rejected. In that case, I am not party in that application. So I am filing this application under Order 7 Rule 11. When that is rejected, then Shankar Shah, defendant number 2, Bolashaw has filed an application with regard to the maintainability of that petition before hearing. Another application.
Maintainability of what petition?
The application filed by the defendant number 2, Shankar Shah, under Order 7 Rule 11. At that is only that application is pending.
And you say the Order 7 Rule 11 itself has been rejected.
Rejected.
So where is the question of maintainability of that rejected application?
That was not filed by Shankar Shah.
Give a notice to the other side and come back.
My lord, we have given notice. My lord, if you lordship kindly see the order.
The directive.
My lord, argument, yes.
Serve a copy of this revision.
Yes, my lord. Yes.
There was no direction of the court. No, there was no direction of the court. You cannot serve unless I direct. Serve a notice to the opposite parties as well as their advocate and come back 2 weeks after.
Lordship kindly take trouble, my lord.
The petitioners seek early disposal of a suit. Full stop. It transpires that there are certain pending applications, due to which this court is of the opinion that the opposite parties are required to be heard before disposing of the present application finally. Full stop. Accordingly, the petitioners shall serve copies of the application on the opposite parties and or their learned advocate advocates contesting in the court below, and file an affidavit of service to that effect on the next returnable date. Full stop. The matter shall next be listed on February 21, 2025.
My lord, I am sorry.
21st February. You cannot serve without direction of court.
My lord, again, I am sorry, my lord.
Come back on 21st. 2 weeks.
My lord.
Serve in the meantime. Please keep it with you. Next. Yes. Yes. What do you say?
3,000 rupees is fine with me.
No, there doesn't appear to be anything on record, any consideration by the court of any material to come to this conclusion that 75 rupees has become 5,000.
If your lordship would want to remand the matter,
I would remand it for this limited purpose. I direct it to be done within a limited period.
Yeah, that would be great.
My lord. Third learned counsel for the parties. Pushed up. The present challenge has been preferred by the applicant in a proceeding under Order 21, Rule 101 of the Code of Civil Procedure against an order whereby occupation charge of rupees 5,000 per month was imposed as a condition for grant of stay of the execution case. Full-stop. Learned counsel for the petitioner points out that the learned executing court did not advert to any material before enhancing the occupation charges to rupees 5,000 per month from the last paid rent of rupees 75 per month.
In fact, no affidavit was called for also.
Full stop. Next para. It is further pointed out that no written objection was considered. Next para. Learned counsel appearing for the decree holder opposite party opposes such contentions and submits that the amount granted is commensurate with the market rent in the area. Full stop. Next para. However, I find from the impugned order that not a single line has been attributed by way of reason for coming to the conclusion as to the occupation charges being fixed at rupees 5,000 per month. Full stop. Moreover, I also do not find that the learned executing court adverted to any material before coming to such conclusion. Full stop. Accordingly, CO 2650 of 2024 is allowed on contest, thereby setting aside the impugned order dated June 18, 2024 to the limited extent of imposition of occupation charges. Full stop. The stay of execution case granted by the impugned order shall continue until further orders being passed by the learned executing court. Full stop. The learned executing court, the matter is remanded to the learned executing court for the limited purpose of reassessing the occupation charges upon giving an opportunity to both the parties to furnish documents to substantiate their contentions as to the current market rent which can be fetched by the suit decretal property contemporaneously. Full stop. It is expected that such exercise shall be concluded by the learned executing court as expeditiously as possible, positively within 1 month from the date of communication of this order to the executing court. Full stop. Upon such opportunity being given, the executing court shall fix the occupation charges payable by the present petitioner as occupation charges for by way of condition of the stay order obtained by the petitioners. No orders to cause certain certified copies. The parties as well as the learned court below shall act on the server copy of this order for the purpose of compliance without insisting upon prior production of a certified copy. Now, prothomei affidavit of service filed to be kept. Within a month, it will be
I'm
done.
very grateful.
I'm obliged.
Next. Yes.
My lord, this is my application praying
Yes.
for expeditious disposal of a suit for declaration and recovery of khas possession. My lord, pending before learned bench senior division. Your lord,
When was it filed?
yes, my lord, suit was filed in the 2019. Thereafter, your lordship, the written statement was as well filed on 5th February 2020. My lord will find from page 41.
Any application is pending?
Yes, no application was pending. My lord, previously we have also filed an application of praying for similar nature, your lordship. My lord will find the previous order in page number 24. No, my lord will find from page number 51. That was the previous order. There, at that point, juncture, your lordship, there was an application that was order 29 rule, order 29 rule, my lord, order 26 rule 9. I apologize.
That has been
lordship.
disposed of.
That has been disposed of. But since then, your lordship, there was a
Since when
specific-
did the peremptory hearing start?
Yes, my lord. My lord will kindly take page number 54, your lordship. That was the disposal.
No, not that, not that, not that.
Yes, my lord will take page number.
Show me the last order.
Yes, your lordship. Page, if my lord kindly takes page
Oh,
number
it's still
36
pending for awaiting the commissioner's
Yes,
report.
yes. That is, my lord, the
suit is for
suit for declaration and recovery of khas possession, your lordship.
But it has not yet reached the peremptory.
No. Till date, your lordship, the report has not been filed, and based on this, your lordship,
No other application is
no,
pending.
nothing
We'll
is
grant the trial court 1 year. I'll direct that. I'll request that. I'll direct the trial court. Give liberty to the trial court to pass necessary directions on the commissioner to file the report early. In view of the nature of the proposed order, no prior service of notice on the opposite parties is deemed necessary. The eviction suit. No, sorry. The declaratory suit filed by the plaintiff/petitioner in the year 2019 is still pending. Full stop. It transpires that long time was lost in deciding an application under Order 26 Rule 9 of the Code of Civil Procedure, which was ultimately allowed, appointing a commissioner. Full stop. However, several dates have been fixed for filing of the report of the commissioner, without the commissioner having filed such report as yet. Full stop. Next para. I find from the materials that there is sufficient reason to expect that the suit should be disposed of as expeditiously as possible. Full stop. Accordingly, CO 3273 of 2024 is disposed of with a request to the learned civil judge, senior division at Bongaon, district North 24 Parganas, to dispose of title suit number 34 of 2019 pending before the said court as expeditiously as possible, positively within 1 year from the date of communication of this order to the said court. Full stop. For such purpose, it will be open to the learned civil judge within bracket senior division to pass necessary directions on the commissioner to expedite the filing of the commissioner's report. No address to cause urgency.
Grateful.
Yes, Mr. Trivedi, what is the matter?
Application under section 24 Millard for transfer of the suit and for the defendant Millard.
Yes.
From Millard Birbhum, Rampurhat to any of the court Millard. My contention is Millard that the three defendants are ladies. One is aged about 72 and above, The second is also around 68. Both are cancer suffering. And the third lady is also 62 years of age and she is a permanent resident of Bangalore. Now, for contesting this particular matter, the third petitioner has to come on each and every date to the Rampur Hat Court, one. Secondly, there are threats against her. She has also lodged a general complaint. And I don't want to take that point, but my lord, that is also one of them, that the one of the plaintiffs is the practicing advocate of the learned court below, whereof she is having problem in appointing advocates because most of the learned advocates are retiring from the brief.
The Bangalore lady, she can, it's the same for her, whether it's in Calcutta or Rampur.
No, my lord, because if it is in Calcutta, the other two defendants will be in a position. My lord kindly comes to my annexures. If my lord kindly comes to page 26, my lord.
What is the stage of the suit, Mr. Trivedi?
My lord, it has been fixed for peremptory hearing in the month of March.
26, page 26, yes.
Lordship will kindly see the Aadhaar card of
Yes.
the defendant number one.
Yes.
Her date of birth is 1946. My lord will kindly
That we are not disputing.
Then my lord will kindly see they are cancer suffering. My lord, page 30, both of them. So my lord, if it is in Calcutta, at least they are residing.
The present application has been filed under section 24 of the Code of Civil Procedure for transfer of a suit filed against the petitioners in the Second Court of Civil Judge Junior Division at Rampurhat District, Birbhum, to the City Civil Court at Calcutta. Who's up next para? Learned Senior Counsel appearing for the petitioners contends that the petitioner numbers 1 and 2, who are defendant numbers 1 and 2 respectively in the suit, are suffering from cancer. Full the third petitioner within bracket defendant number 3 bracket closed is a resident of Bengaluru and has to come to Kolkata for the purpose of contesting the suit and thereafter to go to Rampurhat where the suit is now pending, which is extremely cumbersome. That apart, allegations of threats being issued to the petitioners when they go to contest the suit at Rampurhat have also been leveled in the present application. Thirdly, it is contended that one of the plaintiff's opposite parties is a practitioner of the Rampurhat court, and as such, there is some difficulty in the petitioners engaging advocates in the said court to contest the suit. Since a prima facie case for transfer of the suit has been made out in the light of the above contentions, there shall be stay of all further proceedings of title suit number 3 of 2023 pending before the court of the second court of civil judge bracket junior division at Rampurhat district Birbhum till disposal of the present application. The petitioners shall serve copies of CO number 3278 of 2024 on the opposite parties, indicating that the matter shall be listed in the monthly list of March 2025 before the regular bench having determination, subject to the convenience of the said court. The petitioners shall file an affidavit of service to that effect on the next returnable day.
I'm indebted, Lordship. My lords.
Thank you. Yes.
Application for expeditious disposal
of execution case.
Execution case.
No, nothing pending. Order 21 Rule 99.
Lord, nothing is pending. Lord, two applications are pending for issuance of writ of possession and Lord.
Your application.
My application. They have come up on repeated occasion from 1st April 2023, indicating that they have filed an appeal and court is waiting for a stay order. Lord, till date, no stay order has been filed or.
An appeal is pending. We know that, Mr.
But no stay order is there for 2 years, Lord. 1st April 2023, your Lord, you would find that from the order sheet itself.
The appeal has been filed before this court or district?
Lord, it has been for the additional district judge. That's what I'm told.
Should give a notice.
Title appeal, yes. Lord, we have put them on notice also.
Should give a notice to the judgment debtor. Come back after 2 weeks. I'll put it after 2 weeks. Serve notice on the judgment debtor and his advocate.
Lord, mistakenly or whatever, Lord, they have served. Lord, the affidavit service.
No, that you cannot take note of.
Lord, 26th February is the net date.
26th February.
Next date fixed. Lord, bailiff went there. My instruction, bailiff went there, found it under lock and key. Lord, next date perhaps.
Police help, you have applied for police help?
Yeah, police help not applied for.
What are the two applications?
Lord, two applications, issuance of writ of possession and other is breaking open of padlock. Lord, thereafter.
So wait for some time. Why are you moving this application? It will be over.
I do not know, Lord. Again, something will happen. 2 years have passed. Nothing is happening.
Serve a notice and come back. Learned counsel for the petitioner learned counsel for the decree holder petitioner submits that the execution case in respect of an eviction decree obtained by the petitioner is pending since the year 2022 without any substantial progress. Fullstop. Two connected applications, one for issuance of writ of possession and another ancillary application are also pending in connection with the said execution case. Fullstop. An early here disposal of the said case is sought. Fullstop. However, in his usual fairness, learned counsel for the petitioner also points out that an appeal has been preferred against the decree by the judgment debtor stroke opposite party number 1. Fullstop. However, till date, no stay order has been passed in connection with the said appeal. Fullstop. It is argued that the well-settled principle of law is that filing of an appeal per se does not operate as a stay of the decree. Fullstop. Next para, although the contentions of the petitioner are justified, for the ends of justice, in order to ascertain the fate of the appeal till date, a notice is required to be given to the judgment debtor opposite party. Fullstop. Accordingly, the petitioner shall serve a copy of the application on opposite party number 1, indicating that the matter shall be listed next on February 21, 2025, when an affidavit of service to that effect shall be filed. Fullstop. Next para, it is, of course, made clear that the pendency of this application shall not impede the learned trial judge, learned executing court from concluding the execution proceedings in the meantime, if necessary.
Great. 21st.
So serve a copy of this order also, so that they cannot take advantage of this and get time there. That's why the last line. Okay. Yes.
The defendant is the petitioner before
Petitioner opposite party. Yes. What is the matter?
The defendant is the petitioner before your lordship by dint of the order impugned. Their application under Order 39 Rule 7 of the Code of Civil Procedure for local inspection has been allowed. Lord, they had made an application for repair. Your lordship would kindly takes the repairing application.
You are challenging not repair application is still pending.
Repairing application
39.7 has been allowed. That is necessary.
The only case I have before your lordship, considering the fact that admitted position that the building is in a very dilapidated condition, Order 39 Rule 7 will not suffice the purpose, my lord.
26.9.
26.9. Why I tell your lordship, it's absolutely in a dilapidated condition. Kindly takes page 32 once first. It is their own document.
But you did not apply for any application, for any appointment.
That we have said. My lord would kindly takes the order impugned, my lord. At the time of hearing of the application, we had agitated this issue.
Why are you placing 32? Page 32?
Page 32, it is their statement where he has said that the building is in a dangerous position and my lord, chunks of concretes are falling.
So why waste time? Let there be an inspection immediately and
local inspection, my lord.
Local inspection, he'll take photographs.
The schedule of the repair, my lord, and the, my lord, local inspection application. Lord,
yes, sufficient. Age of building need not be considered. What will an expert do?
Expert, my lord, would kindly takes the schedule of the repair.
Which page?
My lord, kindly takes page 99. To note the condition of the suit premises, whether any whitewashing, plastering. My lord, plastering, my lord, will not do. And the repairing application categorically says.
Where is the repair application?
Repairing application, page 108, paragraph 3. Borgas and ceiling, everything is falling down. As a matter of fact, my lord, a part of the premises has already been, my lord, collapsed.
Other feature is also there. I'll make it clear that all the aspects of the repair application will be inspected. The other features covers every component of the repair application. I'll say that these other features that has been granted, that will cover all the components of the prayer in the schedule in the repair application. I'll make that clear. Advocate can do it, advocate commissioner.
But my lord,
What will an expert? Expert on what? Engineering?
expert in engineering, because my lord, a part of has already fallen down. That is the difficulty. My lord.
My lord, already on 11th of December, the commissioner has went there and he has already conducted the first sort of inspection, and he has also filed report. Report
Report has not yet.
has not been filed. And he has sent them notice, but they chosen not to appear at the time.
But he has, my lord, subject to correction.
No, I'll give the trial court
My lord,
liberty
I'm told,
to
my lord,
appoint
the
a
learned
further commissioner
commissioner-
if he's not satisfied.
The learned commissioner, my lord, has given his resignation. He has reclused himself, my lord. I'm told by the. একটু খবর নিয়ে বল।
My lord, on last occasion, the last date was in Monday.
He has recused himself. So where is the? Why did you say that?
My lord, inspection was done. Lordship.
Inspection done, but he has recused himself. No report will be filed.
He has recused himself, Lordship, on last occasion.
My lord, engineer, unless an engineering commissioner, it will be done at my expense, my lord, since it's my building.
Your expense?
Yes, it's my building.
My lord, his application for.
Well, I'll modify this order. I'll direct an engineer commissioner to be appointed at his expense. That exercise will be completed within a fortnight from the communication. The appointment aspect. But the points will be the same. Points will remain the same. I'll say on the repair on the in respect of the schedule of the repair.
Repair, my lord, I will.
Learned counsel for the you are the plaintiff.
No, I am the defendant.
Learned counsel for the defendant number 2 / petitioner in a declaratory suit has preferred the present challenge against an order whereby an application under Order 39, Rule 7 of the Code of Civil Procedure filed by the plaintiff in aid of a repair application filed by the plaintiff has been allowed. Push up, para. Learned counsel for the petitioner argues that a local inspection by an advocate commissioner would not suffice in view of the extremely dilapidated condition of the suit property. Full stop. As such, the petitioner is agreeable to pay the expenses for appointment of an expert, that is an engineer commissioner, for holding an investigation within the contemplation of Order 26, Rule 9 of the Code of Civil Procedure. Push up next para. It is also pointed out that in view of the nature of repair sought, the points of inspection would not suffice. Push up it. Learned counsel for the opposite party submits that the inspection work has already been completed. Push up, however, it is considered by the learned advocate for the opposite party on such submission being made by the petitioner that an application has been filed by the commissioner for recusing himself. Full stop. Next para. Be that as it may, I find from the schedule of the repair application, in aid of which the application for local inspection was allowed, that the repair encompasses not only whitewashing, plastering, and painting, but also flooring, replacement of borgas of the ceiling, and alteration of broken doors and windows. Push up next para. As such, the petitioner is justified in contending that the appointment of an engineer commissioner would more suit the purpose for which the local inspection was allowed. Push up. Accordingly, CO number 3543 of 2024 is partially allowed, thereby modifying the impugned order and directing the learned trial judge to appoint an engineer commissioner within a fortnight from date at the cost of the present petitioner for the purpose of holding inspection to ascertain the veracity of the requirement of the points sought in the repair application, being patch repairing, plastering, flooring, replacement of borgas of the ceiling, color painting and whitewashing, alteration of broken doors and windows, as well as to ascertain the general condition of the suit structure. Full stop. It is expected that the commissioner shall, after being so appointed within a fortnight from the date of communication of this order to the court below, file his/her report as early thereafter as possible.
My lord, would it be my lord's kind sanction to include only one word, my lord, the structural stability, my lord, because that, my lord, part of it has
The
already
condition যেখানে বললাম, and also the condition of the building, condition of the suit structure as well as the structural stability of the same. So get it at his expense. Yes. Next.
Your Lordship, I am for the petitioner for expeditious disposal of a matrimonial suit.
Expeditious disposal of a suit or a
Matrimonial suit pending before Additional District Judge, 5th Court, Havra. It has been filed on 15 Feb 2021. Your
not
Lordship.
February before a court of law. Yes. What is the status of the suit? What is the stage?
Cost, Your Lordship.
Payment of cost means any application is pending. It's for reconciliation.
Reconciliation has failed, Your Lordship, on 5th July 2023. And Your Lordship.
Evidence has started. Very well.
The 6 time petitions has
In view of the innocuous nature of the prayer, no prior service of notice on the opposite party is deemed necessary. The matrimonial suit filed, who has filed the suit, them or you? The matrimonial suit filed by the petitioner has been kept pending since the year 2021, full stop. It transpires that only recently, the attempts at reconciliation have failed and the suit and the evidence has started in the suit. Full stop. Next para, keeping in view the implicit urgency involved in a matrimonial suit, CO number 3552 of 2024 is disposed of by requesting the learned additional district judge, 5th Court at Howrah, District Howrah, to dispose of matrimonial suit number 245 of 2021 pending before the said court as expeditiously as possible, positively within December 31, 2025. Full stop. No orders to cause urgency required.
My Lord, I am for the petition.
Yes.
My Lord, in this, the impugned order, my Lord, I am aggrieved on 2 grounds. My Lord, I have obtained
You're appealing for the opposite party.
My Lord, a decree for mean profit has been passed in my favor. My Lord, initially the suit was filed for recovery of possession as well as mean profit.
Yes.
Possession recovered.
Yes.
Now a decree of mean profits has been filed. My Lord, I have put the same into execution. Now, my Lord, what has happened? That execution has now been stayed. My Lord, I am aggrieved by the manner in which the order has been passed, as well as the grounds on which the order has been passed. However, my Lord, I must also indicate right at the beginning that the decree for mean profits is now being challenged by my learned friend. And my Lord, the same is also being heard by a division bench of our High Court. So, my Lord, that has already been heard once and it has been kept returnable on 17th. So, my Lord, that is there. My Lord, I must draw your Lordship's attention.
Either I can direct this to be listed along with the appeal before the appellate court, or I can,
Or my Lord can simply adjourn it until the appeal is
I'll do
decided.
that.
My Lord, this is premature in a sense. Lordship will kindly take the order passed by the division bench. Also, there is an order by the Honorable Supreme Court. From an appeal preferred by them against the mean profit decree, they preferred an appeal before this High Court.
They preferred the appeal.
They preferred an appeal. They were
on the quantum.
satisfied.
Quantum. Yes.
From that was dismissed. From there, they approached the Honorable Supreme Court. Honorable Supreme Court has directed us to put in 2.5 crores and directed this Honorable Court to dispose of my appeal, which from the decree of mean profit.
2.5 crore to be put in by whom?
By
My
them.
client. We
Oh.
suffered the mean profit.
You have put in that.
We have put in that application. We have put in. There was a delay of 3 days, so we have put in an IA with the draft itself.
And directed this court to hear out the appeal.
Within 3 months. Now, Lordship sees the division bench order. The mean profit decrease without jurisdiction is the prima facie holding of the division bench. Hello, whether this application can remain anymore.
No, my Lord,
It's premature. Kindly see.
My
Kindly
my
cease.
petition, my Lord, may I?
It's a
may I-
commercial dispute filed.
No,
before us.
a stay order has been passed. Division bench has not passed any stay order.
There is no stay order
Neither the
passed by
Supreme Court
anyone.
also. Neither the
Then
Supreme
who has
Court.
passed the executing court itself has passed the stay order.
Yes. My Lord, on an application moved by them on a date without intimating us in our absence, saying, my Lord, a different appeal was pending. My Lord,
Even
since
then-
he's going into the merits, if your Lordship so desires, I can show the impugned order. My Lord, it is very apparent, my Lord, what has happened that has led to the passing. My Lord, will first look into,
But since the
my Lord, the appeal is there. However, my Lord, may I just indicate, my Lord, they had informed the court of a different appeal that was pending behind our back.
this order may be bad, but if we
That is the
vacate the stay
difficulty.
order, the appeal is pending.
That is why, my Lord, I draw your Lordship's attention to that. My Lord, the appeal is being heard out. My Lord, until and unless that is decided.
When is the next date of the
My
appeal?
Lord, 17th of February.
My Lord,
paper books are not yet filed.
But it's
Only
his
the
appeal.
application.
Well, if he says that he can move, well, there's no order of stay.
Of course, but it's a first appeal.
Very
So,
good.
Mal, if this is a bad stay order, then we can set it
Lordship
aside
will-
and give you leave to apply for stay before the appellate court. Do that.
Well, it is already there because
There's no stay order passed
no
by the
stay
appellate.
order because of the Lordship will kindly see the Supreme Court order 2.5 crores
So what? But
deposited.
there is no stay.
So what is not a reasoning? My lord,
No, my lord, there is, my lord, may I?
appeal has to be disposed of, and prima facie finding of the appeal court is the decrease without jurisdiction.
No, my lord, there is no such finding. I do not know what he has handed over.
Yes, this is the order
Of?
of the division bench.
Which order?
Please remain updated.
No, 1 second, sir. Please let me know which order you're handing over to the court. There are two different orders. One
February,
dismissing
5th
my
February
appeal.
2023,
Yes.
which happened a couple of days back.
Very well.
Right.
My lord will kindly.
Kindly see that order.
Very well. My lord, he doesn't. My lord, Justice Mantha didn't say that there is a jurisdictional error and therefore the execution cannot be proceeded with.
Yes.
He has said so.
He says that there is a prima facie erred in passing the degree of mean profit.
And therefore,
Bar
there should be a
created
stay.
by the commercial courts.
Therefore,
The act.
Mane.
Yes. It's a
The appeal is fixed on 16th February.
17th of February.
17th February. So I'll keep it sometime in March.
application perhaps is fixed.
Or may I just indicate your
Well,
lordship
it's
will
perhaps the
kindly
application which is fixed. Because
But
this is
you
the
have not
first
asked for any stay.
not obtained any stay anywhere.
We have not. Because the Honorable Court was hearing, in fact, the jurisdiction point, they had taken up also a point of demurrer. So if that is decided, my lord, the question will not be there. Once the stay application is disposed of, my lord, we would have asked for a stay. And my lord, in all fairness, it's understood in their appeal, we have deposited 2.5 crore. My lord, the execution.
No, see, if a stay order, even if a stay order was passed, one grievance of yours could be that, I mean, there should have been a condition of putting in because it's a money decree.
No, my lord, may I say what
2.5
exactly
crore has
happened?
been deposited.
No, my lord, may I exactly say
Yes.
what has happened?
Yes.
My lord, he has spoken about a few steps that he has taken and remained silent about the others which he has not taken. My lord, first I had preferred an appeal before this court as a first appeal. My lord, on the ground, I was not happy with the amount of interest that was given to me.
Yes.
My lord, that appeal was heard on contest. My lord, copy of the order, my lord, I have affixed over here, annexed over here. My lord, he contested that application, keeping quiet about the fact.
That appeal is still pending.
No, that has been disposed of. I have gone up before the Supreme Court now. My lord, that appeal was dismissed, but my lord, dismissed on contest where he appeared and he kept quiet about the fact that he had supposedly filed an appeal title appeal before the learned the lower court. He kept quiet about it, my lord. The division bench heard my appeal and was pleased to dismiss it on contest. We went up to Supreme Court. When we went up to Supreme Court, my lord, he informed the court that the appeal that was filed before, erroneously, he says, has been taken back and now has been filed before the High Court. So when the Supreme Court said, very well, since there is another appeal, let that be decided first and then you come back before me. Well, that was the direction of the Supreme Court, because of which now Justice Mantha's division bench is hearing out their appeal, where now they have filed a Section 5 application as well as other applications. I have also taken out an application challenging the maintainability of the appeal. Well, Section
No,
5.
there is a stay application also. Affidavits have been directed to be exchanged regarding both.
There is a stay application.
They have
No.
filed a stay
Yes,
application.
yes.
So let us await the
That is what. Well, that is why I have
You're right.
The SLP is also pending before the Supreme Court.
You are right.
That's
my lord,
on 29th April.
Learned counsel for the petitioner contends that the impugned order whereby the executing court granted a stay of the decree for mean profits passed in favor of the petitioner is bad in law, being devoid of reason. So further, the title appeal quoted therein is not an appeal against the decree of mean profits preferred by the opposite party, by the judgment debtor opposite party. Next para. It is pointed out by learned counsel for the judgment debtor opposite party that an appeal was preferred by the petitioner against the decree of mean profits, being dissatisfied with the quantum thereof, which met with a dismissal. Thereafter, the petitioner has preferred a special petition before the Supreme Court, where the Supreme Court expressed an opinion that an appeal filed against the decree of mean profits by the judgment debtor ought to be disposed of within 3 months, and also directed an amount of rupees 2.5 crore to be deposited by the judgment debtor. As such, it is contended by the opposite judgment debtor opposite party that the present revision is premature. full stop, in any event, comma, two orders, comma, one of the Supreme Court and the other of a coordinate bench of this court, which is in season of an appeal preferred by the judgment debtor against the mean profit decree, comma, has been handed over in court and are kept on record. Full stop. It transpires from the order dated February 5, 2025 that the coordinate bench has fixed the application for condonation of delay as well as stay filed in connection with the judgment debtor's appeal on February 17, 2025. Full stop. Hence, comma, as rightly pointed out by learned counsel for the petitioner, comma, it would be now, for the sake of judicial propriety, comma, the present revision application should be postponed after the said date. Full stop. Accordingly, let the revisional application be listed next on February 28, 2025 under the same heading. Full stop.
Only one thing, ma'am.
Learned counsel are requested to apprise the court of the outcome of the condonation application and stay application before the coordinate bench in the meantime.
Only one thing. The Supreme Court matter is pending and kept for listing on 29th April. My lord, unless the quantum is fixed there, they are not satisfied with the quantum. How can the execution proceed, my lord?
That he has to obtain a separate.
No, they are entitled to execution at least in respect of the admitted
They
quantum.
are challenging the entire decree.
No, they are challenging that portion of the quantum which has not been granted. So the other portion remains in their favor. They can execute.
Part execution will proceed.
You are right on that also in a
We
sense.
have only challenged the
That cannot
We consider that. I'll consider that.
interest only.
No, whether you can proceed with part execution.
Very well, my lord.
Mr. Mal is right on that. So we'll consider that.
Yes, my lord. Because, my lord, the manner in which the order has been obtained, my lord, an application was sent to us saying that it will be heard on a particular date. On a different date, the application was
Let us
taken
hear
up.
out the next matter.
Yes.
Let this be postponed till 21st. Yes. 28th. Sorry. Yes. Yes.
Petitioner, Lordship.
What is the matter?
Petitioner before Lordship is the plaintiff.
Yes.
And plaintiff obtained a degree in the title suit. Therefore, the permanent injunction has been granted in favor of the petitioner. Thereafter, the challenge was made by the opposite party in the appeal. In that appeal, the stay was initially rejected, and thereafter, again, the opposite party filed one application for granting injunction in favor of them. That was also rejected
By the appellate court.
by the appellate court. And second time, they obtained one order against the execution case. That is, Lordship, in the execution case, I got the order, page 82, Lordship. That is in the 19th May 2023, executing court passed the order that on perusal of the affidavit and other materials on record, this court is of view that there is no stay from appellate court. So this court is inclined to proceed with the execution case by issuance of writ. Issue a writ at once. Bailiff is hereby directed to execute the writ at once by breaking padlock, if any, fixed 27 June 23 for execution report. In that circumstances, Bailiff went to the spot and he was restrained. Thereafter, Lordship, the executing against the in the execution case, that page 88, the order passed by the appellate court, first appellate court, that is title appeal 27 or 22, page 88, there was a stay was granted for a part consideration. Lordship, page 88 from the bottom, from the top of the middle of 7th paragraph, it starts with hard learned lawyer 88.
Yes, hard learned lawyer.
Hard learned lawyer for the respondent is not willing to take part in the hearing as prayer for adjournment was rejected. Hard lawyer, learned lawyer for the appellant, some documents have been filed. I have gone through the documents. One title execution case being number 4 of 2023 has been filed before the executing court praying for execution of the decree, which is impugned decree in this appeal. after going through the certified copy of impugned judgment and decree, it appears that it was a decree.
No, no, it's a decree for declaration and permanent injunction.
Permanent injunction.
How are you asking for a writ of possession?
It's
not an eviction decree.
No, I was granted. I want to execute the decree. What position
Injunction
was-
decree is executed otherwise.
No.
Attachment, imprisonment.
Yes, that was.
How can you get issue a writ of possession?
Writ was that in that circumstances, writ of possession was stayed.
Yes.
That is true. Another part is was open for.
What is the impugned order? What happened by the impugned order?
Impugned order is that 208 was.
20, how can you get police help for what?
Police help is required that the possession where my permanent injunction was granted.
Yes.
That the schedule of the thing. Lordship kindly go through.
Where is your application under 2? Let us see that. Page 95. Oh, acha.
Yes.
So you want police help to implement the injunction order so that they cannot disturb your possession.
Because the scheduled property is in my possession. I have obtained this possession. The
208 isn't 208 a misnomer?
No, that
civil lucent orders 208 is for writ of possession. It's a possession.
I am
Anyway,
enjoying-
caption is immaterial. So that application has
I
been
was
rejected on the
enjoying-
ground of limitation.
Yes.
That is your impugned order.
That is
Serve copy and come back, you have a good case. The decree holder stroke petitioner points out that the decree holder took out an application, although captioned under section 208 of the civil rules and orders, comma, for implementation of a decree of permanent injunction obtained by the petitioner to restrain the judgment debtor apostrophe's forceful entry into the decretal property and disturbing the peaceful possession of the decree holder. Such application has been rejected by the impugned order on the ground of limitation. The revisional application is required to be heard on the question as to whether the concept of limitation under Article 129 of the limitation of the schedule to the Limitation Act is at all applicable in case of a decree of permanent injunction, comma, where the cause of action for implementation arises D die in diem, DE, DIE, IN, DIEM. Pushed up next para. Moreover, comma, it is well settled that captions of applications are immaterial and the substance and prayer are required to be looked into. Pushed up, seen from such perspective, comma, it appears that the effort of the petitioner to implement the permanent injunction decree could not have been shut out at the threshold. Full stop, next para. Accordingly, the revisional application shall be heard on the above questions. The petitioner shall serve copies of CO number 3593 of 2024 on the opposite parties, indicating that the matter shall be listed before the regular bench in the monthly list of March 2025 for hearing, subject to the convenience of the said bench. Full stop. An affidavit of service shall be filed on the next returnable date by the petitioner. Thank you. Peculiar order.
Yes, sir.
Number 98.
Yes, Mr. De.
The petitioner being a complainant.
Yes.
Complaint case with the Consumer District Redressal Forum. It was dismissed for default. So an application was filed for restoration. The learned court rejected that application, saying that there is no such provision in that court. Similarly, an appeal was referred before the state forum. And state forum, and there was a delay of about 380 days, along with the section 5 application. The learned chairman, my lord, he heard the matter alone and rejected my application on the grounds, my lordship, kindly only see the impugned order 2 paragraphs. I have not mentioned the name of the advocate.
Mr. De, isn't a revision maintainable before the National Commission?
This is on a technical ground, blood, because
Whatever. There's an alternative remedy. Why should I?
I have also judgment to that effect, blood. The lordship can hear.
Exceptional case. Exceptional. Go before the National Commission.
Yes, brother, because
This will open a floodgate.
it's a technical matter, because the learned chairman cannot heard this matter alone. There is a forum of 3 judges bench.
No, but Mr. De, go before the National Forum.
That lordship can entertain. I have judgment of the Honorable Supreme Court.
The present challenge is against an order passed by the State Consumer Disputes Redressal Commission, in view of availability of alternative remedy before the National Commission, comma, CO number 3633 of 2024 is dismissed as not maintainable with liberty to the petitioner to prefer the self-same challenge on the same grounds before the appropriate forum. No address to court. Sorry, sir.
There are also judgment, but I am holding the judgment.
Yes, there are both ways. There are judgments, but in exceptional cases, patent jurisdictional error and all
How
this.
the chairman alone can pass this order?
There are certain judgments that there was quorum. Other judges, other
The judge forum was the law says otherwise, my lord. How we can
even then, Mr. Next.
Number 20.
Yes.
21 for the petitioner, my lord. This is the application for expeditional hearing
Of suit.
of suit, divorce suit.
What is the stage of the suit?
The stage of the suit is about to take in the evidence. The matter is running for 2019.
No, SDPH. I mean,
Sirampur.
PW1 has started. Oh no,
No,
it,
not started.
next date.
Next date.
Acha, no application is pending.
Only section 36 filed by the opposite party for alimony. That is also pending.
But I'll direct the alimony application to be decided within a limited period. But the suit has to be decided after that. Because if alimony is granted and you don't pay alimony, you are the petitioner.
I'm the petitioner, I'm the husband.
You have filed the suit.
I have filed that.
If alimony is granted, you don't pay the suit, don't pay the alimony, then they are entitled to a stay of your suit. So I cannot direct the suit to be decided before the 36. 36 I'll direct within a limited period, and I'll say as expeditious as possible, the suit will be decided there. In view of the innocuous nature of the prayer, no prior service of notice on the opposite party. No prior service of notice on the opposite party is directed. Push up next para. The petitioner has filed a matrimonial suit against the opposite party, which is pending since the year 2019. Push up. Although the suit is at the suit is on the verge of peremptory hearing, comma, learned counsel for the petitioner fairly submits that an application filed by the opposite party for maintenance under section 36 of the Special Marriage Act is also pending. Push up next para. In such view of the matter, comma, CO 3649 of 2024 is disposed of by requesting the learned additional sessions judge, fast track court at Srirampur, district Hooghly, to dispose of the pending application under section 36 of the Special Marriage Act. You have filed your objection to that application as expeditiously as possible, comma, positively within 2 months from the date of communication of this order to the court below. Push up. It is expected that after disposal of the same, comma, the suit itself shall be taken up for hearing and disposed of as early as the business of the learned trial judge permits.
Time.
No, for the suit, no. For the alimony application, yes.
Number 21.
This is Lordship, my application. I am agreed with the common order passed in appeal by the National Consumer Disputes Redressal Commission. Lordship, I am aware possibly the first hurdle I shall have to satisfy, but Lordship, I am carrying 2 judgments of the Honorable Supreme
What is the impugned order?
Lordship, I am Lordship, both before the State Commission and before the National Commission, I was, my Lord, the opposite party developer.
So shouldn't you go before the Supreme Court now?
Lordship, no. There is no provision in either the 86 Act, which governs this present complaint, or the 2019 Act, which allows for appeals to the Honorable Supreme Court from an appellate order of the National Commission.
You're right, but very well, right. You're right.
Lordship,
but there is no provision revision akin to revision. There is no provision.
no, Lordship, and the Honorable Supreme Court has expressed a view that 227 or 226 should be
Yes,
resorted to.
Justice Khanwilkar, probably the
Justice Pardiwala.
Justice Pardiwala. Yes, there are judgments that High Court can also entertain.
Yes.
Very well. What is the impugned?
My Lord, my grievance with the impugned order is twofold. Admittedly, my Lord, I was ex parte before the National Commission, but I had filed my written version. My Lord, the dispute between the flat purchasers and the developer is simple. It is one of delayed possession. But my point before the...
Who are you? You are
the opposite party developer, Lordship. My point before the State Commission as also the National Commission, my Lord, was that the delay occurred because the complainants had asked for 2 flats to be converted into a duplex. They wanted an internal staircase constructed which would connect 2 flats on 2 floors which is why the KMC came up and rapped me on the head saying this was not an authorized construction. I was deviating from sanction. Be that as it may, my lord, and this is a real estate project comprising 5 blocks. Therefore, my lord, when 4 out of 5 blocks were complete, I had duly applied for and obtained a partial completion certificate. The block in which these flats are situated is complete. I had offered possession way back in 2012. That is when they came up and said, no, my internal specifications are not complete, etc. Now, my lord, before the State Commission, I had filed my written version and my evidence and affidavit. But thereafter, I was declared ex parte. Be that as it may, these pleadings along with documents were there. The State Commission proceeded to pass a common order. There were 2 complaints because of 2 flats. The State Commission passed a common order directing execution of the deed of conveyance and interest on delayed possession. I offered them interest by a check and said, please take possession. They refused. Their point in the appeal, my lord, was whether a partial completion certificate can be considered to be enough for them to take possession. It is my grievance, my lord, that the National Commission proceeded on a different ground entirely, and my written version was not even alluded to in the common order. May I first show the impugned order, my lord? It begins at page 29, but my lord will find the crux of it at page 33 onwards. 30, I am sorry. Page 33 onwards.
Yes,
My lord comes to
33.
paragraph 5.
Right.
The complainants, in spite of having obtained such reliefs in their favor from the learned State Commission, are nevertheless aggrieved on the following 2 counts. Firstly, that the lump sum compensation awarded is not only arbitrary and insufficient, but also unscientific, and the appellants ought to be compensated with appropriate interest for the inordinate delay on the part of the opposite parties. And 2, even while directing the opposite parties to deliver possession of the respective apartments, the learned State Commission passed its order in a rather bland and mechanical manner by ignoring the fact that such possession ought to have been ordered in a completed and legal form, along with requisite completion occupancy certificates to them. Now, my lord, comes to paragraph 6. The aforesaid grievances of the complainants' appellants do appear to be reasonable and genuine. It is a matter of record that the respondents' opposite parties had initially appeared and even filed their replies, but subsequently absented themselves. They adopted the same cause in this commission. Now, Lordship goes on to decide the interest. Now, Lordship, having regard to paragraph 5 and 6 of the impugned order, may I please show, my Lord, page 230, which is, my Lord, the crux on which the appeal proceeds before the National Commission. Page 230.
You placed the order of the National Commission?
Yes, my Lord. That is beginning at page 29.
Yes, right.
Yes.
230.
230, my lord, finds at volume 1. This is, my lord, part of the appeal filed by the...
Right.
Yes. May I place, my lord, the grounds, paragraph 21A and B.
So you are trying to show me that the order did not advert to your actual grounds?
Yes.
But proceeded on a third case?
Yes. The flat purchasers did not take this ground in the appeal, my lord. That is what I wish to show.
Very well.
My lord kindly sees 230, that is corresponding to
yes.
page 19.
Yes.
My lord kindly sees. The present appeal inter alia raises the following grounds, each of which is without prejudice to the other. That the Honorable State Commission grossly erred in not appreciating that there is a distinction between partial completion certificate and completion certificate. The learned State Commission has termed the partial completion certificate as a completion certificate and issued a direction to the respondents. And Lordship, ground B, that erred in not appreciating issuance of partial completion certificate either under the 1990 rules or the 2009.
These are on the completion certificate, which is one of the grounds stated in the National Commission, which is correct.
Only proceeds on interest. My lord, kindly compares once more page 33.
No, 33, one of the grounds stated is that issuance of incomplete. Ground number 2 is all right.
Yes.
Roman 2.
Yes. Now, my lord, the interest portion.
Interest portion, Roman 1, they have no ground on that.
No ground on that, my lord. No ground on that. D, my lord, prohibition from occupying, partial completion certificate. My lord, proceeds to pages 232, nothing.
You have checked up properly?
My lord, subject to correction.
Subject to corrections means I have to read the entire thing.
No ground, my lord. The entire appeal proceeds on, despite having PCC, the State Commission said, go ahead, hand over possession.
No, what about this ground number G?
My lord.
Doesn't it obliquely touch the quantum? Let us just see.
But
Compensate.
they have said that
Yes.
I ought to be compensated for servicing the home loan. That is G, my lord. Kindly see-
Inordinate compensation for with interest for inordinate delay is not there.
No.
That has been granted by the National Commission
Yes,
also.
my lord, may I come back to
What is the quantum granted?
Yes.
But
my
this
lord,
is in the nature of a money degree, then you have to secure that amount.
my lord, my lord kindly comes to page 36, which is
Yes,
paragraph
36.
Yes. Modifying the impugned order passed by the learned State Commission, directing the instead of the lump sum compensation of 1 lakh shall be entitled to interest on the deposits made by them at the rate of 9% each per annum each respective date of deposit till final offer of possession, along with completion and occupancy certificates. And my lord, the other point of grievance is that my written version has not even been alluded to.
But this is in the nature of a money degree. I mean, blanket order of stay, but it has not been quantified though.
No, my
9%.
no quantification.
Really?
And my lord, I am instructed that my client has been ready and willing to offer possession since 2012. The position is unaltered.
The present challenge has been preferred against an order, against the final order passed by the National Consumer Disputes Redressal Commission, New Delhi, in a case arising out of the territorial jurisdiction of this court. Full stop, next para. Learned counsel appearing for the petitioner contends that one of the purported grounds of the challenge preferred by the opposite parties before the National Commission, comma, as quoted in the impugned award, comma, was that the lump sum compensation awarded is not only arbitrary and insufficient, and the appellants ought to be compensated with appropriate interest for the inordinate delay on the part of the opposite parties in delivering their promised apartments to them. Whose next para, learned counsel takes this court through the grounds of the appeal before the commission, from which it transpires that no such ground seeking compensation with appropriate interest for inordinate delay in handing over possession has been made out in the said memorandum of appeal itself. First of that apart, comma, the petitioner also alleges that the written version and arguments of the petitioner were not considered by the National Commission or adverted to at all, comma, which is prima facie justified on a perusal of the impugned order. Full stop, as such, comma, the present revisional application is required to be heard on the above issues. Full stop, accordingly, there shall be stay of operation of the impugned judgment and order.
23rd June.
Yes, passed by the judgment and order dated June 23, 2023, passed by the National Consumer Disputes Redressal Commission in first appeal number 2137 of 2017 till March 31, 2025, or until further order, whichever is earlier. Full stop. The petitioner shall serve copies of the present application on the opposite parties, indicating that the matter shall be listed for contested hearing before the regular bench having determination in the monthly list of March 2025, subject to the convenience of the said bench. Full stop. The petitioner shall file an affidavit of service to that effect on the next returnable date.
My lord, identical order in item 22. Although it was a common order, since there were two first appeals, I have preferred two revisional applications.
22 তে সেম হবে, শুধু নাম্বারটা আলাদা হয়ে যাবে। আর এনিথিং
Only the first
different?
appeal number will change.
Yes, give the first appeal number please, so that I can just dictate. 22 টা বোর্ডে দেখিয়ে দিন।
Are you sure? Yes, 212. First appeal is 212.
Here is the same.
Here is the same.
Date is same, date of order.
Same. It's a common order, my lord.
ঠিক আছে? বুঝলি? ভুলভাল করবেন না। FAT number, first appeal number. Thank you.
23, I want to withdraw this.
Which one? 23 call করে দাও। One petitioner or several petitioners?
Two petitions.
Learned counsel for the petitioners submits on instruction that the petitioners do not want to proceed further with the revisional application and want to withdraw the same. Full stop accordingly, CO 3678 of 2024 is dismissed as withdrawn.
I'm appearing for the item number 23. I'm paying for not to date, my lord.
I'm sorry.
I'm extremely sorry, lord.
23 तो কি আছে?
তুই না পারবি না। এটাই
তুই
তো-
না ও আমি সিনিয়র আছি ও অ্যাডভোকেট আন্ডার মাই জুনিয়র তুই না পারবি তো ইনস্ট্রাক্টর
Who are you?
I'm for the তুই না পারবি না।
Your CO number 3678 of 2024. You don't have any instruction that you want to withdraw the appeal, withdraw the revision.
My lord, I'm just paying for not today.
not
Who is leading you?
I'm
Who is leading you?
led by Mr. Yasin Rai.
Vesenra as in, what is his? Take instruction. Order to get it. Take instruction. There may be some misunderstanding. ঠিক আছে কিছু অর্ডার পাস করতে লিখতে হবে নোট করতে হবে কাম ব্যাক অন দ্য নেক্সট ফ্রাইডে হ্যাঁ সেই জন্য করছি